That was not. You go to the Supreme Court now. They dispose the appeal disposed of by this court. Then no, that High Court after the High Court dismissal of the appeal, have you gone to the Supreme Court? No, Supreme Court's lawyer will not do. You have to go to Supreme Court. No. You can try. You can try, but I doubt you'll. Yeah. Definitely. Thursday. Yes, item 14. I know. It's a 1031 days delay. What instructions do you want? The instructions are all there in your affidavit. He just said deciding. It's a issue of fact. That's all. Hmm? Let me see this case, item 14. You should have at least adjournment slip should have been given. Okay, right. Miss D. Mohanto, learned counsel for the applicant, prays for some time and submits that the written objection has been filed by the respondent. 1 and 2. On the prayer of the counsel for the applicant, lists the matter when? When? Huh? No. This is a small issue. Third, okay. Second week, give a second week. There. You go day after tomorrow. Because day after tomorrow. Why? What is this? Tell me. Has comments, so then appointment has been issued. Appointment order has been issued. Then day after tomorrow. Day after tomorrow. The court also needs some time to read. Day after tomorrow.
ओ भाई ये तो हमारा कार आ रही है
It's not on the screen. This is a part-heard matter, it appears. Then
yes my lord, it's a part-heard matter
so
and we finished our arguments. It's just we had to file whether they were group C and D employees, which we have.
so I think the original bench will be sitting again from tomorrow. Then let it be listed day after tomorrow or something like that.
Yes my lord, yes my lord.
I cannot see you anyway.
My lord, I think my connectivity is poor, so I've tried to get connected, but it's not happening.
Okay.
yeah.
Okay.
So My lord, if it can be another 2 days, any 1 or 2 days later.
Okay, when do you
27th.
want? When do you want? Thursday
27th? Yeah, yes, my lord.
on the prayer of the parties? Huh?
Twenty-seventh, if convenient.
No, no, no. Second, the bench will not be sitting. That. The
Then, my
chief will
lord,
not-
Second bench.
then first,
No, no. The next first, the one. No, no. We'll do it next week. We'll do it on Thursday.
Thursday is
Okay, Wednesday. Right. 26.
Wednesday is 3rd, my lord.
26/11.
26.
Day after tomorrow.
Very well, grateful, my lord.
On the prayer of the parties, list the matter on Wednesday.
We filed, my lord, may just note, we filed our affidavit.
Miss, yeah,
Luthra.
we cannot see anyone. It's just incognito. You are appearing for whom? Respondent number?
We are for the petitioner.
You stand this side. No, you confuse us when you stand. Yes, petitioners are always this side. Okay, so you have filed an additional affidavit. Okay, right. The petitioner's counsel submits that additional affidavit has been filed. Registry to place the same on the call. This is the matter. They have to know.
Grateful. Very grateful.
Yes. Why after 3 weeks? Mr. Dina, you're there. You're for whom?
Again, he is in the set.
Appellant is the state. No, item 3, no? This is the issue where he has been discharged. 2 persons, so you have taken a stand that there are 2 causes of action. So why are you wanting to adjourn the matter? Look, next time, please give an application for adjournment. When? Oh, you send. Oh, I don't know. Okay. I was in Kohima that time. Okay, right. On the prayer made by Mr. D. Nath, Leonard, counsel for the appellant, which is not objected by the respondent, list the matter. List the matter after 3 weeks. Yeah, give a date. What is this? You file an application. What is so difficult? No, no. 8th. Yes. Huh? Why? You see? Huh? 7. This is with regard to the marks. Is that regard to the appointments? Huh? Is this with regard to that selection process where one person got the higher mark and the person who got the lower mark was appointed? Is that the case? What is this case about? Oh, that driver. Okay. Who 2009, 2013 you're terminated. Ha. Okay. When do you want? Why do you want to adjourn? What personal difficulty? Whose personal difficulty? Who's your senior? Mr. BJ Fukan. For the respondent? Huh?
Number 7.
7. Okay, item 7. Item 7. Okay, right. On the prayer for adjournment made on behalf of Mr. PJ Fukan, learned counsel for the appellant. List the matter when? Huh? Yes, you should be. After 42 years, you come to the court. No, what do you want today? If they want some more time, what do you expect to achieve today by the submissions they are going to make? Can we? No, they need more time. You come after 42 years. I think if they want a few weeks, when you juxtapose that, I think they're. You see, there's another aspect. Right now, maybe you're coming on behalf of only 4 persons. And this could now snowball into a petition involving thousands. You see, it's not so simple as you think it is, or you make it sound it to appear. So it's only a question of money. You're on the question of the amount of money. So basically, it's a question of money. Instead of 1 rupee, you want 10 rupees. Basically, that's the thing. And now you wake up after 43 years. No, I agree. We are. Anyway, let us see. Let us see, madam. One thing you see. First of all, your petition is going to snowball from 4 writ petitioners to I do not know how many. It's quite apparent. Number two, they have been able to survive for the last 43 years, and basically the issue is of money. So I don't know, let them file their affidavit. If you just keep that in mind, that is going to snowball. Wait, let them file their affidavit first. Let them file their affidavit. Wait for some time. You have waited 43 years to file your petition. You can wait for another few weeks. Heaven will not fall. Miss P. Barwa, learned. Huh? Okay, that, no. Let them file their affidavit. We'll see. No, that's the submission they made. We are recording that. All right. Third, Miss W. Farashat, learned counsel for the petitioner. Ms. R. Barwa, learned counsel for the state respondent, submits the that some instructions are forthcoming from the chief secretary, and the same will be submitted in the form of an affidavit within 4 weeks. List them out after 4 weeks. When do you want? Second week is a holiday. Our third week. Give a date. Okay. It won't take long. Clear? What is your interest? So what? PL doesn't mean that you file. You're not the crusader for the entire population in India. Huh? You're also a ex-student. You tell the authorities there, the college students to take the college authorities to take up the issue. Why are you taking up the issue? So then if it is near to your case, if it is near to your land, just next to your land, you file a case against that person. Huh? Huh? That is a different thing. Hmm. Hmm. So, but then in this PIL, your case is different. Your case is that it has encroached upon the college land. You file a case against that person saying that your rights have been violated. Huh? No, that is not your case here. That is not your case here. Your case is only against the respondent number 5. 3. Huh? No case. And now he is saying that. Mr. Counsel, if your land has been affected, you file a case. We cannot go in a roving inquiry just because if we will have thousands of cases this way. This is not a you see, PIL cannot be used as a weapon. Then let the college take up the issue. They are not, there's nothing between you and this person. Yes. Huh? Huh? So how does it affect you? Is the college a poor juristic person that it cannot take up its own cause? Is it helpless? Have you taken up the matter with the college authorities? How? By orally, verbal, verbal will not do. Sorry. Causing trouble to you. Where have you said that? That where have you said that in this petition? Where have you said that in the petition? Yes, Mr. Nayak. No case. We are. You want to withdraw? We are allowed to withdraw. Others we are dismissing a case. There is no case. We cannot take up a. You want to fight against the respondent number 5. You go to the Supreme Court. You file a case there. We are dismissing your case. Yes, Mr. Nayak. Anything? Yes. We, okay. They are fighting.
Oh.
They are. What is the case numbers?
That is why he came.
4562 of 2024. 5024 2025. This with regard to the land constructed by building constructed by the respondent number 5. You withdraw. You want to withdraw, you withdraw, or will impose cost upon you, heavy cost.
Better to withdraw, I think, yeah. What kind of public interest people, I think?
Okay, good. Heard, Mr. Heard, Mr. What is the name? Mr. S. Sharma, learned counsel for the petitioner, who prays that he may be allowed to withdraw the writ petition. Full stop. Next para. Mr. P. Nayak, the learned counsel for the respondent number. Respondent for the respondent number 1,
One.
1, 2, and 3. Submits that he has got no objection to the prayer for withdrawal made by the petitioner on account of the fact that there are two cases, WPC 4562 of 2024 and 5024 of 2025, in which the petitioner and the respondent number 4 are at loggerheads with each other. In view of this prayer made by the petitions council, the writ petition is dismissed as withdrawn. You do whatever.
You want to do.
Item? Yes, what is your case? Huh? You are challenging the order of the cat. Huh? In the criminal case, he got benefit of doubt. And in the departmental proceeding, remove from service. Any challenge to the departmental proceedings? Where is the order of removal? Page? This is 1419. The date of the order is 1st April 2019, is it? So in the DP, he has been removed. Correct. In the criminal case, he was acquitted. So now this order at page 90 has been put to challenge before the CAT. Now, what is the decision of CAT? Let us see. Let us see that. Yes, yes. Where is the criminal case acquittal? — 108. Okay. So basically, he has been this removal order has been set aside only on the ground that you did not you did not pass the order within 2 months. Huh? Huh? What? 11 years after? When was the DP started? When? 2017. DP started in 2017. Okay. No, so whatever, it found that you were guilty. Correct. As per DP. But criminal case, you were found, you are acquitted. Yes. So what is your submission? Whatever. Yeah. So you're the writ petitioner. I mean, not writ petitioner. You were the petitioner before the CAT. 168. Yes. Yes. No, that suspension is a different issue. The issue of suspension is not a question. Just one thing. When the memorandum of charge was issued to you, you submitted a written statement of defense. Then after the proceedings, the inquiry, then after the inquiry, you were given the second show cause notice. The inquiry report was given to you or not? There's no inquiry report. No. Where do you prove that the inquiry report was given to him? I know that much though we know. We are look, please be prepared. You see, these are the basics of a departmental inquiry. There has to be a memorandum of charge. There has to be a chance for filing a written statement of defense. Thereafter, the inquiry start. After the inquiry report is made by the inquiry officer, the same has to be sent by the discipline authority to the delinquent officer to make his representation against the inquiry report. Has that been done? What do you mean that is structural? That is a different issue, Mr. Counsel. There are some questions which we want to clarify first. Another thing, Mr. Counsel, there is no bar for a DP to take come to a different decision. Just because the criminal court has said that they are acquitted, that also due to benefit of doubt. There is no bar for a DP to come to a different finding. Okay, that much so you know, because that's on the preponderance of probability. So the only thing is here is, and it does not appear that the cat has decided any issue at all. It has only basically said 11 years. But the fact remains whether according to you, did you get any inquiry report for which you were given the opportunity to submit a representation? No inquiry report. That does not have to be a ground. That is an issue that can be taken up by the court. We are not bound to confine ourselves only to what you say. Anyway, you get that information, then we'll decide. Because if no, the second the show call was not issued, then we'll set aside everything, and we allowed you to continue from that stage. You see, there's no point because you cannot have a finding without complying with that second show cause notice. Delay charge sheet, how does it matter? There's a charge sheet is filed, that's all. And then you have been acquitted. Why do you want to go into the issue of delay charge sheet? How does it help you? You want to shoot your own foot? How does it help you? Right. Heard, Mr. S.K. Medi, learned counsel for the Appellant Union of India. And Mr. K. Roman, learned counsel for the respondent. Respondent Kavita. Respondent number 1 or sole respondent? So sole respondent / Kavita. Who has been removed from service by a departmental inquiry, departmental proceeding. Right. Next para. The appellants are aggrieved with the impugned order dated 23/5/2025, passed by the Central Administrative Tribunal, Guwahati Bench, in original application number 040/96/2021, by which the order dated 1/4/2019, by which the respondent had been removed from service, has been set aside. Wait, 1/4/2019 and the order dated 30/09/2019, which has upheld the order of removal, correct? What is that order? Just show me which page. Page 194? I know. 194 is a letter from Sajban Begum. Just a minute. This is a letter from the respondent. So why should it set aside this letter? That is what I want. 39 2019. Where is that? Where is that page? Give me that. Why are you giving me 194? Who's asking you for that response letter? What is this letter? No. Wait. Okay, what is it? And letter dated 30/09/2019, by which the respondents have rejected the request of the respondent to, no, by which the appellants have rejected the request of the respondent to reinstate her into service. Ah, next para. The case of the respondent is that, no, the facts of the case is that the respondent had been suspended on account of non-crediting 32 recurring deposits while she was working as extra departmental branch postmaster bracket EDBPM at Khagra Bari branch post office. Full stop. Next para. Due to the shortage in the office cash, in the cash in the office, due to shortage of cash in the office, on the above issue, a criminal case was registered against the petitioner. White Paneri PS case number 31/2009, bracket GDE number 97 dated 6/7/2009. This is at page 164. Huh? After charge sheet had been submitted, GR case number 1179/2012 was registered against the respondent. System. The court of the SDJM bracket S Udalguri, BTAD thereafter acquitted the appellant of the charge framed against him under section 420 IPC against her by giving her the benefit of doubt. Full stop. Next para. Thereafter, the appellants submitted a memorandum of charge dated 24/7/2017 along with a corrigendum dated 2/8/2017, in respect of the departmental proceedings that had been initiated against the respondent for having. Where is the memorandum of charge? Page. For having shortage in office cash amounting to rupees 5,917.60, and in view of the respondent not crediting the 6 SB account deposits in the respective passbooks and into the government account amounting to rupees 7,050, and also for not crediting ten RD accounts. No, not crediting the deposits in respect of 10 RD accounts. Full stop. Next part. The petitioner submitted his written statement of defense. Correct? Correct. Written statement of defense against the memorandum of charge submitted by the issued by the appellants. Full stop. Next para. The respondent thereafter put to challenge the memorandum of charge dated 24/7/2017 before the CAT Guwahati bench, while original application number 040/0065/2018, page 142. Huh? And first up, the respondent also prayed for payment of arrears salaries. First up. The CAT Guwahati branch thereafter directed the appellants to conclude the departmental proceedings against the applicant, against the respondent, within a period of 2 months, and to release subsistence allowance to the respondent as per the rule. Next part. The next para, the appellants thereafter concluded the departmental proceeding initiated against the petitioner, while order dated 1/4/2019 by holding that the charges framed against the respondent had been proved. And inflicted the punishment of removal from engagement, which would not be a disqualification for future employment with immediate effect. Come to page 89. Para 4. Okay, what have I said? And next. A copy of the inquiry report was thereafter forwarded to the respondent for submission of her defense representation, for submission of her representation on the inquiry officer's report. However, the respondent did not submit any representation against the inquiry report. Next part. The respondent thereafter put a challenge to the impugned order dated 1/4/2019 before CAT Guwahati bench, wide original application number 040/000652/2018. Oh, no, sorry. 04096/2021. Full stop. The No, thereafter the learned tribunal wide order dated wide the impugned order dated 23/5/25 disposed of original application number 040/96/2021 on the ground that disposed of by setting aside the impugned order of removal dated 1/4/2019 and the order dated 30/09/2019 by which the appellants had rejected the respondent's application for reinstatement into service. The reason for setting aside the above order dated 1/4/2019 and letter dated 30/09/2019 is reflected in para 6 of the order dated 23/5/2025, which is as follows. Take it down. Page 169. Next para. As can be seen from para 6 of the impugned order, the reason for setting aside the impugned order and letter has been made due to the fact that the appellants had failed to comply with the order dated 28/9/2018 passed by the tribunal in OA number 65 of 2018, wherein the departmental proceedings had been directed to be concluded within 2 months. However, the same had been concluded after 7 months. This conclusion of the departmental proceeding had been made 13 years after her suspension. 13 years after the suspension of the respondent, and that too after acquittal in a criminal case instituted out of the same cause of action. As such, the learned tribunal held that the removal of the respondent from service was not sustainable, as the same was not in consonance with the acquittal of the respondent in the criminal. We have heard the learned counsel for the part. As can be seen from the records and the submissions made by the counsel for the party, the issue to be decided is whether a departmental proceeding, whether the decision in a departmental proceeding has to be in the same vein as given in a criminal case. The second issue to be looked into is whether there has been any procedural lapse or illegality in the departmental proceeding that had been initiated and proceeded with against the respondent. Okay, we'll complete this later. It takes some time. So basically disposed of. Basically allowed. Take this one. I think 17. Yes. Page page 53. Page 53. What is wrong with the rules? So what is wrong? Mr. Kaushal, your service in a provincialized school will start from the date you are provincialized. Why should your past service in a private institution be counted? Huh? Yes. Day of joining as a government teacher or as a private school teacher? What? Government teacher. So you, when were you appointed as a government teacher? 1994, huh? 1998, you were appointed as a government teacher in a government school. Government teacher in a government school. So let us see your appointment order. No, let us see your government. Let me see your order. Your statement will not do. You have no reneged. Now you tell me, when was the schools provincialized? So your school, which school were you in? Which school? Huh? Annex page 23. Subject without as science teacher, assistant teacher in one ME school. So, so, so now you want to be considered for the post of principal, huh? For principal high secondary school, and you are appointed. And what is the requirement of the rules?
So for that position, my initial appointment is concerned, my lord. I was since graduate teacher, my lord. Thereafter, I was not transferred
What
to
is
high
wrong?
school, my
Tell
lord.
me that the rules
Yes, sir.
is the same for everybody.
He's speaking. So far,
You're not making sense.
Must have rendered
Huh?
at least
17 years.
17 years of teaching experience as graduate teacher in any
High secondary school.
So for my service in high school, whether that will be counted or not counted, that has to be my lord. I have made in here, silent.
No. When were you a graduate teacher in high school?
Yes, my lord. Then my lord, I in the year my lord, 2007, my lord.
2007.
2007,
You are a graduate teacher in
high school. My lord.
high school.
So my lord, 70, my lord,
Huh?
my seniority of 17 years will be counted from 2007.
If but the rules provide what?
Only my lord, higher secondary school.
So what is wrong?
That is the my lord,
Is there any discrimination?
Any my lord graduate teacher who cannot serve in a higher secondary school can my lord apply for the post.
Why? What?
Because my lord, my seniority cannot be curtailed, my lord, as graduate teacher.
Why can't the
But yes, sir.
what is wrong with the law? What is wrong with the rules?
Now that pointed out, that has been my lord modified, my lord. Amended rule has been come into force with effect from my lord 28 October 2021, my lord.
2021
Yes.
rules have been amended.
Amended.
To what effect?
My effect is that my service is also my lord included here.
Then
My lord, now matter is not my lord is infectious.
the matter becomes infructuous.
It has been amended now.
So it has become infructuous. Okay, right. Mr.
Thank you, sir.
MP Sharma, learned counsel
Thank
for the MK Sharma, learned counsel for the petition submits that the writ petition has become infructuous as there has been an amendment
My lord, Assam Secondary Education Council
to the just a minute to the Assam Secondary Education Provincialized Schools close service rules, 2018, by an amendment made in the year 2021
Yes.
by way of
My lord, Assam Secondary Education Provincial School Amendment Service Book 2021.
okay. Only amendment is that to be added. So Miss J. Chutia appears for the
number 5 and 8.
this point number 5 and 8, while Miss R. Baru appears for this point number 2. Two, on account of this, 26, on account of the submission made by the Leonard Constable for the petition, the writ petition is dismissed as infracted.
My lord, this matter relates to transfer of a criminal investigation from Bongaigaon to any other investigating authority.
I thought you wanted CID or
Yeah.
something like that.
And
Why?
in the meantime, they have filed an affidavit, copy has been served on me, and they have stated in the affidavit that they have filed the
That's it.
charge sheet
Yeah, then-
altogether.
So then-
my lord, I am withdrawing this.
So nothing remains. So you're not pressing this matter.
I am not missing.
Okay, right. Heard Mr. A.K. Buyan, Leonard Counsel for the petitioner, who submits that during the pendency of this case, the state respondents have submitted a charge sheet
Right.
in respect of the allegation of rape
Yes,
made against the respondent number
9,
right.
9.
He accordingly submits that he does not wish to press the writ
Yes.
petition. Ms.
S. Sharma.
S. Sharma appears for the
Respondents number 1 to 5, lordships.
My lord, respondent number, not respondent number 9, my lord, 10, my lord.
head.
Respondent number happens to be the judicial magistrate.
Appears for respondent number 1 to 5.
No.
And anybody else? CJ Mahanta appears for respondent number 7 and 8. On account of the submission made by the petitions council, the writ petition is closed as is closed.
Deeply obliged, lordships.
I see your lordship. This petition is fine, my lord. Excelling the legality and ability of some land acquisition petition act 1964. Consequent rules also.
As
In-
consequent,
And the connected rules, my lord, then under that law. And my lord, because the Land Compensation Transparency Act passed by the Parliament in 2013. After passing of that act, my lord, the central act, my lord, this has become my lord, defunct, my lord, slightly repealed and repugnant. This cannot operate like this law. Here, my lord, what happened, my lord? Finally, see the, my lord, annexers, I have annexed the documents of landowners, my lord, this 20 petitioner before your lordship. From page 44 to 63, my lord. These are the, my lord, documents of they are the patta holders, Miadi land holders, my lord. What happened in this matter, my lord? They have issued only a notice or order, my lord, under section 7A of 1964 Act, giving some amount to us, which is below the 1/20th of the current value, my lord, market value. And treated us like a beggar, my lord, and they are as if landlords. My lord, and that, my lord, without serving any notice, without following 64 Act, even without following the 13th Act or any rules, my lord.
when was your land acquired?
My lord, we have not given any notice of acquirement, only the 7-1 notice is up. And in that regard, I have.
Show me this land acquisition act.
Yes.
Assam Land Acquisition Act.
My lord, in this connection, my lord, 3-4 similar petitions are, my lord, pending in our court, on similar grounds, my lord. And that is also, my lord, admitted notice issued, my lord.
Look, presidential assent has been given or not?
My lord, given the part of it, only one amended part of it, not the.
Which
not the-
part of it?
The parent act,
Which part of it?
not this amended 24 amended in my lord.
Under Article 254, has a presidential assent been given?
My lord. The parent main act, my lord, parent act is not given, my lord. The parent act 64 is only a part of it amended is got given, assent given, not, so it is not applicable, my lord, in this year. It is by Article 14, my lord, and 308 clearly. Look, there is judgment also, my lord, in this regard, Supreme Court judgment, I have, it also, my lord.
What do you mean? They cannot be different land acquisition acts.
Cannot, my lord.
Why not? National Highways Act is there.
My lord, but should be, but all should be come under 13 Act, my lord. How to, the fair compensation.
No, not all.
Following this law, but compensation and this procedure.
There is a schedule given under the 2013 Act. It's not there.
My lord, yes, my lord, yes, my lord, your lordship is true, my lord, correct, my lord. There some schedule is given, yes, that is a schedule given, yes, some X are given, my lord, they will not come under this act. But it is state act, my lord, not highway act, it is state act acquired by PWD. Not national highway, my lord, it is a, my lord, alternative airport road, my lord, airport road, my lord.
This 64 Act is still in force or there has been an amendment?
My lord, after 13 act, it is impliedly repealed under section article 254(1), my lord.
There's no question of impliedly repeal. Where's, show me the 2013 Act,
Yes.
show me the relevant provision. I think you're dealing with section 114.
My lord, as far as article 254(1), my lord, once the concurrent, my lord, concurrent list act is passed by parliament, my lord, state legislature is can be passed. And those who are inconsistent will not, my lord, come into force, my lord. And my lord, if they can enhance the, my lord, benefit of the landowners, but cannot do anything otherwise, my lord. Only that they can do, that much they can do.
Come to section 114. Page 75.
My lord, correct. 1894 is act is repealed, is central act.
Then
My lord, central act is repealed.
there is no implied repeal of the
My lord,
64 Act.
My lord, as per article 254(1), my lord, once the concurrent list is, my lord, either or any act is passed by parliament, the parliament will, my lord, override the state my lord, act, my lord, and my lord, particularly those who are inconsistent with the, my lord, with the central act, and my lord, it is a specific provision is there, my lord, they can pass law, but by increasing the benefits of the, my lord, the landowners, but not by otherwise, by decreasing or, my lord, differentiating or discriminating, they cannot. My lord, section 107 of, my lord, this 13 act, my lord.
Show us where is the repugnancy? Where is the repugnancy? Where is the repugnancy between the 64 Act and the 2013 Act?
My lord, articles, so far as I understood, subject your lordship's opinion, my lord.
No,
My lord,
I cannot make the law.
no.
The constitution is there to help us.
Interpretation is made by the honorable courts, my lord.
But you have got to tell us what is your grievance.
My lord, yes, grievance is that, my lord. They are the Miyadi Patta land owner, my lord.
No, not on the facts, on the law.
Law, my lord. Law, my lord, law is that, my lord.
Once we are clear with the law will take care of the fact.
Yes. My lord, under article 254, my lord, when the in a concurrent list, my lord, subjects in concurrent.
I agree.
My lord.
But where is the repugnancy?
My lord, yes. Kindly turn to page, my lord, 28.
Yes, Mr. We are not heading anywhere. Yes.
My lord,
What to
kindly
do?
page 28, details, my lord, given.
So he has already filed a writ petition before the learned single judge on the same facts and circumstances. That writ petition, my lord, in that writ petition, my lord, the issue here is with regard to, my lord, widening of the 4-lane road to 6-lane road for the new terminal in Lokopriya Gopinath Bordoloi International Airport. It's a national infrastructure project. Now, part and parcels of land were acquired. The land acquisition proceedings were drawn up. It had culminated into passing of an award. And when the notices were issued to the persons, to the, my lord, landowners, that you come and receive the compensation, then they raised grievances to the extent, my lord, that they are not satisfied with the quantum of compensation. Be that as it may, my lord, under the scheme of the 1964 Act, they can, my lord, raise their grievances before the reference court, my lord.
There's a reference court.
The reference court, their provision is that nonetheless, my lord.
No, but now he's challenging that 1964 Act.
Therefore, now everything has culminated, and there was an initial stay order, my lord, passed by the learned single judge to the effect, my lord, that they will not be evicted. That stay order was, my lord, modified. That stay order was modified, and we were given the, my lord, we were given the leeway, my lord, to proceed with the work, and the work is now complete. They are out of their land.
No,
So
no,
far as the
you see,
contract is concerned.
what we can gather
Yes,
is that he wants a better deal.
he wants a better deal.
So
13 tech, only under.
So he says, according to him, he can get a better deal under 2013 Act. And in terms of the law laid down, I mean, various decisions made, he should be allowed to take advantage of the better deal.
Better deal.
So he says that the land should not be acquired under 64. At the end of the day, that's what he says.
Yes.
Yes.
It's not under 64, but under the 2013 Act. Now, when was the land acquired?
Land was acquired,
When?
my lord, in the year 24,
2024.
2024. And it is our case.
In tax, my lord.
It is the case of the state that the quantum of compensation that the petitioners will be entitled would be calculated in terms of, my lord, the 2013 Act. So they will not be deprived.
Nowhere they have said so, my lord. What happened?
So
my
they
lord?
will record their
My
statement.
lord, my lord, kindly,
Lord,
kindly,
lord,
my lord,
lord.
they-
No, Mr. Counsel, just a minute.
My lord,
We'll record their statement
Yes,
that
yes.
you will be given compensation as per the 2013 Act.
13 Act.
Now,
This
you see,
is what we are
2013
doing.
Act, what is there? What is there under
yes,
this?
my lord, my
You
lord,
see, the market rate,
My
please
lord.
listen.
yes. Yes,
As per the 2013 Act or as per the 1964 Act, the market value of the land has to be given. Correct. Now, solatium under the 2013 Act will come to how much? Any idea?
my lord, 100%.
Huh?
100%.
100%. Under the 64 Act.
900, approximately
My lord,
900
we are-
of the Distaman.
So you'll get 100% solatium. Interest how much?
my lord, 12%.
Are you sure? Are you sure? Please look at the interest.
My lord,
Look, you show me under the 1964 Act how much interest you're going to get.
my lord, my issue is not there. My kindly, my lord, my humble submission is before going to the award, there are things to be followed. Now, what happened, my lord, under their 64
You mean that rehabilitation?
Well, not only that, my lord, not devolution, not on that, man. What happened, my lord? There is under 13 Act, my lord, land record should be updated. I should be heard, and if any objection, 60 days time should be given. My lord, the details, my lord, will be given, my lord. Nothing is done for
Anyway, is it your case that you have been given compensation for a less area than you are entitled to?
not only that.
No. Is it true or not?
Yes, my lord.
Where have you stated that in your affidavit? That my land is 100 square meters, but I've been given compensation for only 50 square meters. Where have you stated
I
that?
have not, my lord, this case is not filed only on the award compensation, my
I
lord.
agree. But then you see, the facts also has to support the law that you're trying to apply. You cannot just make a
My lord,
case out
my
just
lord,
for
my lord,
just for the
kindly-
sake of
kindly
argument.
Give me 1 minute, my lord. Here why the starting act is important for us, my lord. Not only for the award, my lord. In the, my lord, updation part section is there, my lord. They have to update what happened, my lord. The land, our land is in the name of others, my lord.
Oh,
My lord. And my lord, in the name of, they have done
yeah,
it, my lord.
Benami transaction.
My lord, no, my
Huh?
lord. No, my lord.
Your land is in somebody else's name.
My lord, it is not that, my lord. It is our, my lord, inherited property, my lord. What happened, my lord? In my 5 brothers, suppose, my lord, they added another 1-2 persons unknowingly, my lord. Now they are giving compensation to them also. And also, my lord, there is the provision in the 13 Act. They should update. Suppose, my lord, fathers have died.
Is there a provision for reference for taking up all these issues in the 64 Act?
64 is there. We are not on 64. That's why, my lord. The 13 Act. We want 31. My compliance of 13 Act, my lord. And my lord, kindly have a look, my lord. As a single prayer, my lord. Kindly, last page, kindly take note of, my lord. What is happening to this 64 Act, my lord? Kindly have a look. My lord, last page, my lord, of my petition, my lord. Kindly have a look. Page 152, my lord. And before that, my lord, LA case number 27 of 95. My lord, what happened, my lord? Our forefathers has given the land. My father has given the land. He is expired. Till we have not got the convention under 64 Act because of departments, my lord, harassment and all these things. They went to Supreme Court, my lord. I have announced the order of LA 595's case, my lord. Because 96 for there is no protection of the, my lord, landowners, proper protection, my lord.
We don't even know whether a father son also there.
My lord,
There probably it appears that there is some disputed questions of fact.
no,
Then.
my lord,
Huh?
that is why, my lord.
That is
why.
that. So that because what
he-
you're saying is that some others have also taken compensation as your brothers.
Yes, their name is entered in our land.
Name. So they're disputed questions of fact.
And they are supposed to, my lord, they are supposed to correct it as per section 13 Act, my lord. Number two, my lord, they have.
Can't it be done under the 64 Act?
My lord, no, this is 64's my result, my lord, and listen, 95 compensation yet not been given, my lord. 95, my lord.
Okay, the award was given under award was made under which act?
64, everything has been
But
done.
64 has been amended. They've been repealed. There's the 2024 Act now.
No, 2024 Act, so far as my lord, that quantum of compensation is required, my lord, there is an amendment to the schedule and that schedule.
Okay,
is also
24
put
is only amendment to
to-
schedule.
Yes, that schedule is also put to challenge here, my lord. Now, here is a case where everything has, my lord, ended up. And now he is only with regard to the compensation. He is hitting, my lord, the records of rights. Now, at the time of, my lord, acquisition of land, authorities will go by the record of right. If he have any private dispute, it is for him to settle it out.
There is
We will
64
go by
Act.
that.
There is another 64 Act. My lord, kindly see, my lord, section, my lord, 11.
So he's not the landowner right now.
No, we recognize him as the pattadar.
You recognize him
Yes.
as a patta landowner.
He may raise so many disputes. We have issued initial notice under section 3, then notice under section 6. Gazette notification has been done. When everything was done, we had issued a notice under section 7 that please come. And there are 2 land acquisition cases involved in the entire projects. Over 900 pattadars. Everybody is happy and contented, save and except these 20 persons, these read petitioners.
My lord, I have say on that.
They want some more. That.
Missing.
They have a remedy. They have a remedy under section 12 of the 1964 Act.
My lord.
What more can I submit, my lord?
My lord,
We'll take it up again. We'll take it up again.
my lord, our land is taken one side, others still, let's say, taking both sides. That is also a prayer of our prayers of there, but take it both sides so that we can be, my lord.
You see, you're coming to the division bench. I thought only on a question of law. You're coming,
My lord, kindly,
I-
13 Act, my lord, section 11, my lord, kindly see.
we'll see, because we'll have to consider your other writ petitions also.
My lord, that is pending from us, that their prayer was that, my lord, they have not reclassified, not issued notice, not
We'll
64
see,
Act,
we'll see.
13 Act, no
Right.
act is there, my lord.
This is the matter again. On Thursday.
Apply.
That writ petition is, my lord, the next date is fixed on 2nd of December. That writ petition
My lord,
before the honorable single judge.
there, I have, my lord, my prayer was that, my lord, no law is complied. Neither 64, nor 13, nor reclassification, no act. No law, only foreseeable. My lord,
That's right. The case of the petitioner is that the Assam Land Requisition and Acquisition Act 1964 should be set aside. And the law to be applied for acquisition of the petitioner's land should be however, the transfer of land 2013 Act. 2013 Act, okay? This is the matter on the other hand, Mr. Mr.
Arbor Pujari.
R. Bor Pujari, learned counsel for the
I appear for the revenue department.
Revenue Department, submit that the petitioner has filed 2 writ petitions.
One writ petition.
Has filed another writ petition. That is WPC number
6374 of 2024.
6374 of 2024, which is pending before the learned single bench pertaining to the acquisition of land for approach to the new international airport,
My lord. New terminal of
new
the
terminal of the
LGBI airport.
LGBI airport. in
My
Bharat.
lord.
This is the matter, sir.
my lord, make you on 28, my lord.
28.
I didn't file for admission.
I am obliged.
Better?
May I please your lordship, lordship, the grievance of the petitioners before this honorable court is that there is no avenue for promotion to the next level. On the last occasion, lordship, the matter was taken up before the court number 1. I was requested to look into the matter, lordship. I have taken it up with the authority. And my instruction is, lordship, it has been this scope for promotion, lordship, that is being examined and it is under examination, lordship. So at this stage, lordship, I am aware that this honorable court would have the power to direct the authorities to develop a scheme for, in fact, they do not have any promotional avenue. I am with them in that respect. Court has also got the power to direct for framing a scheme for their promotion. But since the instruction is that it is already under examination, at this stage, what I would request your lordship is, your lordship will kindly place it, say, in another 4 weeks' time, and lordship will ask for a report. What is the progress, lordship?
Okay, right. Heard Mr. R.K.D. Chaudhary. No, heard Mr.
A. Chakravarti,
A. Chakravarti and Council for the
petitioners.
I'm having a
petitioner.
copy of the instructions, lordship.
And Mr. R.K.D. Chaudhary, the learned deputy is here. The petitioners are aggrieved with their promotional avenues having been taken away by the respondent.
But the rules of 2012, lordship.
By the rules of 2012. Next para, Mr. R.K.D. Chaudhary submits that in pursuance to the order dated 15/10/2025 passed by this court, he had made inquiries with the respondent and he was accordingly issued a letter dated 21/11/2025 by the Assistant ADM Officer HQ ADGBR bracket East. Gustav. In the said letter, it has been stated that the case for providing promotional avenues to welders is under process with them by amending the R&P rules in respect of
Equipment mechanic.
equipment mechanic so that turner, welder and machinist can be included in the feeder cadre to the tune of 10% of the vacancy. On account of the instructions received by the Mr. R.K.D. Chaudhary via letter dated 21/11/2025, lays the matter again in January 3rd week. By which date the respondent should give a status report with regards to the issue to be decided by the
Lordship.
Right.
কেতিয়া দিলে?
Item 6.
In that Himasa tragedy, that my lord, that whole mining. Your lordship kindly see order the 15/9/2025. (15/9).
Yes.
My lord, this, your lordship with the last but 3 para, my lord. Mr. D. Soikiel and Advocate General Assam has submitted that for the details, affidavit has been filed. Derailing the steps have been taken by the stopping the gap hole mining in area, but a commission of inquiry is also looking into the matter, which asked for the objection from the stakeholder. Hence, therefore, prayer is that matter listed for the month of November 2023, affecting the attention. So what
But
happened?
my information is that the tenure of the commission has been extended for another three months, my lord. This is the order of 6
Probably, my lord.
2010. The report has not been submitted. For further 3 months, it has been extended. No?
See, another aspect
this-
of the
this-
matter
This anything?
is when you look at the affidavit of the respondent number 8.
Yeah, that is the.
Out here, it has been
My lord, they have
stated
to file affidavit, my lord. Your lordship.
that this Assam Mineral Development Corporation is the authority which allots the permits to the mines
Lordship.
for operation of mine. And accordingly, they should be a party because this Assam Minerals Development Corporation, they'll be giving these permits all over the Assam.
My lord,
Those who are under the my lord mineral land.
Correct,
Those-
but you see, they could be giving,
No,
they
that's
could
why,
be,
my lord, your
they
lordship-
could be giving permits even to the rat hole mining.
My lord,
No.
that's it.
That's
That's
all.
why, my lord, the your lordship can see them, the JSUTL and Standing Council, Caribbean and Disclosure County responsibility. Their affidavit is also very important because it is going on in their area. That order, very last order. Standing Council, my lord, Council is yet to file affidavit.
My lord, that incident occurred in the North
Oh,
Kasaragod
whatever it
Autonomous
is-
Council.
No,
But our
but then-
affidavit is ready, my lord, we are going to file it today, my lord.
Oh, very good.
We are going to file it today, my lord.
And have you identified any rat hole mines?
My lord, in my lord.
Or everything is done scientifically in your place?
No, my lord, but autonomous, Caribbean Autonomous Council does not have the power to issue the mining permit, My lord,
Maybe,
for that, my
we're,
lord.
we're not asking you to issue.
my lord.
We're just asking you to find out whether there are any rat hole mines in your area. That's
My lord, there is an inquiry conducted by the district commissioner, my lord, along with the forest official, my lord. That inquiry report may have, my lord, government may have the report that some piling of the coal is there in some areas of the under our jurisdiction.
But from Mines and Minerals Department, we have filed an affidavit. Lordship, page number 14 is the affidavit. There, my lord, we have stated in paragraph 4, my lord, that these are actually abandoned, my lord, some places are there. And unauthorizedly, the person, they have started that thing, my lord.
But
And
there-
in that, my lord, if Lordship kindly comes to page 15 of the affidavit, my lord, there we have stated, my lord, that married, my lord.
Hmm.
This is the affidavit filed by respondent number 1, 2, and 7.
I don't have that, I think.
Page number, it running page is 14, my lord, 1/4.
I don't have that.
It was, my lord, filed on 6/2/25, my lord. 14, 1/4.
Not here. Wait,
1/4. No, honey,
14,
ভুল হয়েছে নাকি আমার?
1/4. Ah, yes.
Yes, my lord.
Yes,
No tag out.
This is filed by the Joint Secretary to the Government of Assam Mines and Minerals Department. If Lordship kindly comes to para 4, my lord.
Yes.
The deponent states that the information about the coal mine accident reached the Government Disaster Management Authority in the evening on 6/1/2025. It was informed by the local resident that in the vicinity of the coal mine that some laborers descended into a huge 300 feet deep vertical well pit having many narrow horizontal red hole tunnels below the digging and extracting underlying coal site inside. The laborers were working inside the red hole for digging coal below the ground. While the laborers had been working in the red hole tunnels, the laborers might have reached one of the abandoned red hole mines full of water and dug open accidentally. As a result, huge gushing water flooded in the inside of the well through the tunnel. It has been reported that while some of the laborers who were inside the tunnel managed to escape, but 9 laborers were suspected to have been trapped inside. As soon as the information was received, the Additional Chief Secretary Mines and Minerals Department mobilized the rescue team by forming a WhatsApp group. Honorable Minister started for the accident site on receipt of the information on the same day. The Additional Chief Secretary to the Government of the Director, Geology and Mining and other officials also reached the accident site on the following day morning. The National Disaster Response Force, State Disaster Response Force immediately came into the action in the rescue operation and later.
What do you want to?
What are the steps we have taken? And in fact, my lord, we have stated, my lord, that red hole mining is not permitted, my lord. In fact, not permitted. And the entire district-wise report we have in the next affidavit, we have.
What we'll do is
Yes,
we will
let-
make this Assam Minerals Development Corporation a party,
Lord.
and they should give a list,
Yes, detailed report.
detailed list with regard to the mines to whom they have given permit
Lord.
for the state of Assam, in the entire state of Assam. Last year and this year, entire list.
Well, atoll mining is illegal. Everybody knows what it is going on.
You look at you look at area Latimbai. One day, once if an earthquake happens that
Nothing
that-
happened, then
that-
it will be okay. But if it happen, my lord, then they are all active now. And here lordship can that tragic incident, nobody knows but how many persons died there.
Lordship, with my lord's permit, I'm for the intervener, Lordship, I'm an RTI activist. And the local inhabitants and a local executive member of the autonomous council, that's it, Lordship. We had sought for an ITI with the Department of the Guardian Autonomous Council. Surprisingly, Lordship, we wanted that the coal mining in that area, the revenue generated from the coal mining should be given to them. Surprisingly, Lordship, in respect of coal mining, mining for the sand and stones were given, but in respect of mining, nothing was given in the RT. Had that been the case, Lordship, this mining would not have come to all.
the revenue made or the permits given, so some revenue generated
Generated, Lordship.
and they given to which
This
department?
Illegal part of the mining has been going on.
It is the revenue
Lordship.
is given to whom, to which department?
Paragraph 8 of the 6 schedule, my lord, revenue is required to be shared between the autonomous council and.
No, but then where do they deposit? They must be depositing somewhere, the persons who have mines.
I have.
Or
done-
or you can have mines for free.
No, if the mines are allotted by the department by a process, then absolutely they have to give us. But these are illegal mines, my lord,
No, I'm talking about the legit
the
mine.
legal mines.
Yes,
In that case, my lord, the mines and minerals department is there.
the mines. So I think the mines, the department should also furnish an affidavit stating the revenue that they have received from each and every mine that has been working in the year 2024 and 2025.
One affidavit we have filed,
Yeah.
lordship directs, my lord, will
Yes,
definitely, will file.
So then we can pinpoint that which are the mines that are legit or not
Lordship,
later on.
my lord, my lord,
Could be a time bomb.
my lord.
Anyway, right. The matter pertains to illegal rat hole mining in the state of Assam, particularly with regard to the incident that occurred in Umrangso in Dima Hasao district of Assam on 6/1/2025. Pusta. Next paragraph. The affidavit filed by the respondent number 8, that is the principal secretary in charge, North Kachar Hills Autonomous Council, is to the effect that the NC Hills has no role to play in the present PIL. However, mines are auctioned by the Assam Mineral Development Corporation, bracket AMDC. On account of the affidavit of the NC Hill Principal Secretary, we are of the view that the AMDC should be implemented as respondent number
Respondent, one number.
respondent number 9.
9. Phone number 9.
Respondent, aim registry to accordingly make necessary correction to the cost type for improvement of AMDC as respondent number 9. Who is appearing for AMDC?
Possibly notice will go, my lord.
Okay. Issue
Otherwise, for
notice-
department, we are appearing.
issue notice to the what will it be? Managing director?
Managing director.
To the managing director, AMDC. Any idea where the address is?
Soxy. AMDC.
Through the Department of Mines and Minerals,
Minus,
Government of Assam.
lordship.
through the secretary to the government of Assam, Mines and Minerals, government of Assam.
Or Lordship can say respondent number 7,
To the point number 7.
Director Geology and Mining is there.
To the point number 7.
Lordship.
Next para. The respondent number 7 shall also submit an affidavit with regard to the revenue it has earned. Acha, before that, the AMDC shall submit an affidavit with regard to the revenue it has earned from auctioning mines all over the state of Assam for the year 2024 and 2024 and 2025. Full stop. The respondent number 7 shall also file an affidavit stating the revenue it has earned from giving permits for the running of mines in the state of Assam and give specific details with regard to the revenue earned from each mine that is working in the state of Assam for the year 2024, 25 and the year 2025-26. That's all. This is the matter. When?
Well, Lordship, in respect of coal, my lord, because here we are, coal, some other minerals may be there.
Okay.
Lordship is concerned
Right,
with coal.
In respect of coal, huh? In respect of coal.
Coal, Lordship.
This is the matter when?
No, notice will go, Lordship may keep after 4 weeks, my lord.
This is the matter on 18 December.
Lordship. Outline, নহলে
My lord, KAC, my lord, they have to file affidavit.
Who?
Karbi Anwar.
Mr. J. Chutia submits that. The KAC will be filing affidavit in a position today.
During the course of that.
During the process.
With your lordship. This matter relates to selection and appointment of a principal in a college.
Ah.
Now, what happened, my lord? There was an advertisement and pursuant to that advertisement, the selection was made. And the private respondent number 1, she got better marks than me. But although my lord, the selection committee recommended her name for appointment, the appointing authority, my lord, appointed me. On the reasons, my lord, that has been stated. Now, my lord, this order of my appointment has been challenged by the madam.
Let us see the advertisement first.
My lord. Advertisement your lordship will give at page 54. 54, 54.
Which are the two clauses?
Second column, my lord. Application are invited with complete biodata and supporting testimonials from HSBC onwards for the post of principal, Bhubaneswar College against regular vacancy. Then your lordship may skip, my lord. Your lordship may come to clause 5. That is
Yes.
important. A minimum of 10 research publications in peer-reviewed or UGC listed journals and the minimum of 110 research score as per appendix 2 at table 2. Now, my lord, the case of the my lord, private respondent is that my lord, she had received more marks and the selection committee recommended her name. Therefore, I could not have been appointed. That is his case. The petitioner also filed a writ petition, my lord, subsequently after obtaining the credentials of the
appellant, you mean?
appellant. I'm sorry. The appellant also filed a writ petition, and both the petitions were decided by the honorable single judge. And the petition of the my lord private respondent was allowed, while my lord my writ petition has been rejected, dismissed on the ground that my lord I have come late and it is only an afterthought.
No, you see, your name, you were appointed
I was appointed. I'm
on the ground that you were you belong to the BTR.
My lord, in fact, that I belong to BT area that may not hold good, my lord. Although the fact
It
that
did not hold.
It will not hold.
It's only preference.
Although my lord, the fact remains that, my lord, at least 18 teachers have been appointed by the authorities, my lord, who have received lesser marks, but, my lord, they were appointed.
Not
because-
challenge probably.
Anyway, my lord, that is against the law, ma'am. And I have not challenged those appointments. My case is very simple, my lord.
Your case now is very simple.
In my case now is simple, my lord. I am not.
You are challenging that he does not have the minimum of 10 research
Yes,
publications.
my lord.
But
And, my
was
lord,
that an issue taken up in a writ petition?
in fact, my lord, that I had taken
Did-
up in my petition, my lord, that has not been, my lord, discussed. That has been rejected on the ground, then this is an afterthought. Effect will be, my lord, a person who does not have the eligibility, who doesn't have the eligibility will now be appointed.
Okay.
That is my lord, the precise point that your worship,
So what did the single judge say?
my lord.
What did the single judge say?
My lord, so far as my petition is concerned, my lord, the finding your
With,
worship,
with regard to these 10 research publications, what did it say?
my lord, your
Page-
worship, my petition has been rejected. If your worship comes to that finding at page, my lord, 527. I had taken all these grounds, my lord, because subsequently there was a committee constituted by the.
Anyway, let us see 527.
My lord, paragraph 23.
Yes.
Therefore, having regard to the manner in which the postal principal has been processed to be filled up in accordance with Assam College Employees Provincial Rules 2010 and the requirement in terms of the AGC Regulation 2018, the dispute raised by the petitioner in WPC 598, my petition, cannot be accepted, and it also appears to be an afterthought. The fact remains, my lord, after, my lord, this selection was made, there was a committee constituted by the authorities.
What is the finding? What is the respondents have to say with regard to this?
My lord,
With regard to your stand regarding the petitioner not having, the respondent not having that 10
my
people.
lord, the respondent says that I have all the qualification, that is the statement they have made. But my lord, a committee constituted by the authorities, my lord, that has gone into it, and that finding your worship will find, my lord, at page, my lord, 465. So this report is in existence, my lord. 465. This is a minus of the meeting of the committee constituted for re-verification of the research papers published in journals submitted by Dr. Pratibha Patwari and Dr. Pramod Mehta.
Okay, who are you? You are
My lord,
Pramod Mehta.
I am Pramod Mehta.
And the other one is Dr. Pramod
Pratibha Patwari.
Pratibha.
For the postal principal, Bodheswar College, by notification of the successor. The committee has had a sitting on 1st June 2024 at 11:30 AM in the office chamber of the Secretary Education, Queensland. The chairmanship of such and such. After careful verification of all the research papers published in journals by the candidates in question, the committee unanimously arrived at the following conclusion. Regarding research papers submitted by Dr. Pratibha Patwari, Dr. Pratibha Patwari has submitted 10 research papers, and out of these, only one paper has been published in UGC here listed journal and is valid for consideration. Another 4 papers are neither published in the index nor in the peer-reviewed journals and hence may be rejected. The peer-reviewed status of the validity of the remaining 5 papers could not be confirmed due to a lack of pertinent information. Regarding the research paper submitted by Dr. Pramod Mehta, Dr. Mehta has submitted a total of 20 papers. Out of these, 18 papers are valid for counting, 5 papers are published in Scopus index journals and 13 in the peer-reviewed journals. Remaining 2 papers are not published in the peer review. So this is the finding of the committee. Therefore, my lord, if the honorable single judge's order is, my lord, allowed to stand, then, my lord, the person who is not eligible
Has been allowed to.
My lord, so far from the record it appears, my lord, the person concerned who was who secured highest mark was not accommodated, and the second highest was accommodated. And according to the learned single judge, it violates Article 14, my lord.
No, we have got no qualms with that.
Yes.
That article, that single judge is correct in that.
Yes.
But with regard to these papers,
Now, so far papers is concerned, my lord, learned senior colleague of mine has taken to page 465, my lord.
Yeah.
Now, regarding this, my lord, the marks secured totally by the committee itself, my lord.
There's no
Then
question
you-
of marks here. There's no marks.
My lord, with regard to research papers and all such things, is been subject to scrutiny by the selection committee, my lord. And according to the selection committee, the highest person was the Dr. So-and-so Patwari. So in that view of the matter, my lord, in view of this pending writ appeal, my lord, whole of the matter was placed before the Executive Council of the BTC. It's newly been formed, my lord. Recently, Principal Secretary has been appointed and it's been put up before this. And the EC has taken a conscious decision with regard to this, that they will be complying with the Honorable High Court's order. And that EC, my lord, that happened on 2011-2025, my lord. But that publication is not been done because of the, my lord, all this vacation, all these days, and the Principal Secretary is in Hyderabad, my lord, because of some personal reasons, my lord.
No, so at the end of the day, the issue remains the same. Has the eligibility criteria required in the advertisement,
Yeah.
has it been fulfilled by the concerned respondent?
It's been fulfilled, my lord. As far as selection committee, that's
Where is
why.
that?
Lordship, this,
You are for,
I'm for respondent number one,
One.
Lordship.
and you are for the,
I am for the BTC, my lord.
no, so
Yes.
now this issue of the
465.
eligibility criteria,
Annexure, my lord, page
come to page 54.
50.
Yes, Lordship, in page 50.
No, just a minute. I'll give you get that, sir. Come to page 54.
Yes, the advertisement, my
Yeah,
lord.
the second column, come to number 5.
A minimum of 10 research publication, so journals, and a minimum of 110 research score as per table 2.
Yes.
Yes,
Now the question is,
yes.
has this minimum of 10 research papers been
yes.
published
Yes, Lordship.
in peer review? No, just a minute. Has this been published?
My lord, at page 465, if your lordship appreciates that, my lord,
Yes.
the minutes of the committee of considered
Yes,
re-verification of so and so,
Yes.
my lord. Regarding research paper submitted by Dr. Pratibha Patwari,
Yes.
Dr. Pratibha has submitted 10 research papers. Out
Correct.
of this, only one paper has been published in UGC CARE listed journal and is valid for
Only
consideration.
one.
Another 4 papers are neither published in index nor in peer journal, hence may be rejected. The peers so and so validity of remaining 5 papers could not be confirmed due to lack of so and so. Regarding research papers submitted by Pramod Medi, Dr. Pramod Medi has submitted total 20 papers of this. 18 papers are valid for counting, 5 papers are published. And in 13 so journalists, remaining 2 papers are not possible so. A detailed report with regard to Richard so committee has directed Director so forward the minutes of the meeting to BTC authority. Now, as for this, my lord, so far advertisement is concerned, that is at 5, my lord, clause 5 of the advertisement is concerned, my lord. Minimum 10 research
10.
paper, both of them, my lord.
No. He's got
No,
13.
no.
13 in the peer reviewed journal. 13 in the peer reviewed journal.
And a minimum of 110 research score, my lord, as for appendix 2. My lord, with regard to this, my lord, may I be allowed to take the instructions, my lord? Because a conscious decision as for this, my lord, is been taken by the EC decision that they will comply with the High Court's order.
No.
Now, so far with regard to this portion is concerned, my lord, as for this 465, it appears, my lord, 20 papers out of which 18 papers are valid. 5 papers are published. So publication is required under
And
this
seen in the peer review. You see, it has to be published in the peer reviewed journal.
reviewed or UGC, my lord.
Yes, so it's
Listed journals.
13 are there. So
Oh.
for the appellant, he's covered the basis
10, it's more than 10.
more than 10.
More than 10.
Now for the respondent,
Yes.
he has got only one that can be accepted.
Yes. But the advertisement also talks about the other criteria with regard to this.
Correct.
So overview,
You see,
whatever score has been there,
Uh,
it's been the other person concerned.
No. The score is there,
Yes,
but this is with the minimum eligibility criteria.
yes,
5 is the criteria required. These are the conditions. You see, otherwise, if you say that these are not the conditions, if you say these are not the eligible conditions, then you don't have to have a master degree with 55%.
correct, my lord.
You
Absolutely.
can say that 35% also.
Yes.
So this is the eligibility criteria.
Yes.
So as per this eligibility criteria 5,
Ah.
the respondent does not appear to have the eligibility criteria.
My lord. Yes. So we were covered. Yes. Let me submit, my lord. With regard to this, I have to obtain instructions. My lord.
Yes.
May it please your lordship. Lordship, the honorable single judge was very much correct. Lordship, as per the page number 54, the advertisement, we have fulfilled all the criteria. Lordship, if I may take you point number 5. The point number 5 says a minimum of 10 research paper publication in peer reviewed or
Correct.
or.
Or.
So lordship, in 10 minimum of 10 peer reviewed journals, we have
Where does it
completed.
say in this page for 465?
Lordship,
peer
Lordship,
review?
this page 465, this is a re-verification committee. This
Correct.
Lordship,
Re-verification committee made by the respondents themselves.
no, Lordship,
Made by whom? By you and me.
Lordship by BTC Lordship, but the re-verification committee was done by the VTC Lordship, but Lordship, we had fulfilled the criteria and the honorable single judge was very much.
You see, that is why there is sometimes re-evaluation, there's a review, there is always, we to reconsider, there's always that issue is always there. Supreme Court also sometimes reviews its own decision, reconsiders its own decision. Sometimes they miss out. Everyone misses out. You see, these are questions of fact. This is not question which you and me can decide.
Yeah.
It's a question only the authorities can decide. Now, as per page 465, which is a reconstituted committee for re-verification, it has been made by the BTC themselves. All members, chairman, member, secretary, all of them. Now, they have said that you're not eligible. Your papers, only one can be eligible in terms of the advertisement.
Lordship, in my humble submission, Lordship, regarding this thing, Lordship, this 465, page number 465, this re-verification committee was not correct, which was
Not correct.
Lordship,
You see,
in that, Lordship, if I may submit, Lordship, Lordship, I'm being led by my senior, Mr. K. N. Chaudhary. He's on legs. Can this matter be taken after some time? He will be able to satisfy your Lordship regarding this point.
Yes, let him come. We'll wait for him. We'll wait for him. That's the only thing. We'll wait for him. Before lunch, let him come.
Yes, yes, Lordship.
It's 12:25. That's it. We'll wait for him.
My lord, submission of Mr. Unia is concerned, my lord. The decision that has been taken now by the authorities he has submitted, my lord, that is only to the extent of whether the single judge's judgment has to be, my lord, complied with or not.
Or not, correct.
That, my
Correct.
lord, they, because, my lord, I have only preferred appeal.
Ah.
Unless there is an order here, my lord, they are bound to comply. So that does not go into the merit of the eligibility of the, my lord, the respondent. And, my lord, in the affidavit of the, my lord,
No, anyway, so you were selected.
I'm selected,
Were selected by the single judge ruled against you.
no, my lord,
No,
in
no.
fact, I was appointed.
You're appointed.
I'm still working.
We're still continue. Let's see. For the timing, we'll be here. We'll finish it, and by lunch we'll have our decision, because this is here. Unless there is something new that he can point out.
Lordship.
Our
This matter relates to Lordship's second pension,
Item
item 20.
second pension. Yes.
Second. Yes, sir.
কিবা number revision?
20.
নহয় আমাৰ।
No. Lordship, initially he was in the army. And he retired, he's getting the first pension. Thereafter, he was enrolled under the Defense Security Corps. Now, the tenure that he has to put it, as per the army regulations, is
14,
15 years.
15 years.
15 years. He did not complete 15 years. He had some 10 months and all left. And that is why he was.
As per which provision which provision is that as Army Act which one?
I have quoted it in my.
Which one is it?
Lordship will come to page 11, Lordship.
Page 11.
Paragraph 125 of the pension regulations for the army. It starts.
Yes.
Paragraph 125 of the pension regulations for the army, 1961 part 1, dealing with condonation of deficiency.
Okay, 6 months.
Yes. So that is.
But he has to complete. So only 6 months can be given
That is.
condonation.
Now, there was, I would just fairly submit before your lordship, there was a decision of Maharashtra, Bombay High Court, which was again taken in appeal. In that case, it was a case under the Navy pension regulations. It was a case under the Navy pension regulations.
Navy pension regulations, year, which year?
That is. Navy pension regulations 1964, and the regulation was 82A.
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 What did 82A say?
That was regarding the period that has.
But what did it say?
But in fact, I've got the judgment on record of the
Yeah.
Supreme Court that your lordship will find at page 62. And this was an appeal from the judgment rendered by the Bombay High Court. And since the union had not filed an appeal, that had retained final.
No, I just want to know what 82A says.
If your lordship will come to page 63. It is not quoted, but in the fifth line, there is a provision in the Navy Pension Regulations 1964 for condonation of shortfall in service. Initially, it was for 6 months, and subsequently the condonation was made permissible for 1 year. The respondent claimed that he was entitled to the benefit under the said regulation, and the Government of India instructions dated so and so. The appellant denied the said benefit to the respondents by the order dated 14th August 2001. The respondent initially approached the High Court of Delhi by filing a petition number so and so. It was pointed out before the High Court that the revision bench of the Bombay High Court in writ petition 430 of 2005, that is Gurmukh Singh versus Union of India, by judgment dated 22nd November 2006, declared the Navy Pension Regulation 82A as null and void, being ultra-virus to Article 14 of the Constitution of India. So it was on that premise. But here.
No. Regulation 82A provided that.
Benefit of condonation of shortfall in pensionable service shall not be applicable
To the case.
in which a senior sailor got discharged from his service at
His own request.
Here it is not at his own request, lordship.
So there is a provision in the Navy regulation
Yes.
that minimum qualifying period of 15 years. If you are short of that, then you can get a condonation period of 6 months. Same as your Army Act, Army regulation.
Yes.
Okay, same.
Now that was struck down by the Bombay High Court.
That 82A.
82A. Then it says that up to 1 year if it is on his own request.
So whether it is own request or not doesn't matter
It
anymore.
doesn't matter, but the rules that were before the Bombay High Court and the Honorable Supreme Court, those were the Navy pension laws. Pension regulations.
But that is not the issue here.
No, here.
No, what I'm saying is out here it does not, the page 11 that you have taken us through does not speak of own request. Acha, it is own request. Okay, that is own request. That
Yes.
is.
Now, here is a case where we are dealing with the army regulations lordship. And taking cue from the judgment in the, which I have just shown you lordship, tribunals have held that no, they are eligible for that condemnation. But I want to bring in a differentiation.
No, I understand. No, this is simple. Basic thing is, Mr. Counsel, in that other case, under the Navy regulation, that 82A has been set aside, has been quashed. So that provision has been quashed. Now, in your case, this
It is.
125A has not been quashed.
Yes.
But that does not matter. But there also, there was a provision to allow this condonation of the qualifying service for only 6 months.
My lord, may I permit, my lord?
So out here is also 6 months. So what is the difference?
By virtue of the Supreme Court order, now they have got 1 year. Now, if he gets 1 year,
No, why have they got 1 year as per the Supreme Court order?
no,
When the regulation says 6 months,
yes,
why should they be given 1 year?
so that was given.
My lord,
No,
new
fine.
regulation says, my lord, up to my lord 12 month, my lord.
New regulation of which
2008, my lord, army regulation here, my lord.
2000.
My lord. My lord, kindly see, my lord, page number
2008.
2008, my lord. Kindly see page number, my lord, 3 first, my lord. Number 2, my lord, the rule 2, my lord. The all, my lord, rule is superseded, my lord, and revised, my lord.
Page 3.
Page 3, my lord. Rule 2, my lord. The
Page three,
regulation
rule-
in the part superseded the regulation.
Rule 2. Rule.
The regulations.
Just a minute.
Fine.
You are talking about the act or the rules? What?
Regulation, my lord.
Regulation.
Regulation, my lord.
Page 3 does not have any rule 2.
My lord, kindly see, my lord, rule 44, my lord. Page number 25, my lord.
Yes.
Page 25, my lord. The 44 rule, my lord. Deficiency in service for eligibility to pension gratuity may be condoned up to 12 months, my lord. In each case by competent authority except in other ways, my lord.
Yeah, I accept it.
2008 rule, my lord. As per the new rule, my lord, I am entitled, my lord.
But what about this? It says the deficiency in service for eligibility to pension may be condoned up to 12 months in each case by the competent authority, except in the case of an individual who is discharged at his own request.
My lord.
Except for an individual who is discharged at his own request.
My lord, this is exceptional, my lord.
Huh?
Deficiency up to 2 months, my lord. This is clear, my lord.
Huh?
12 months, my lord. My lord, that condone, my lord.
Except in the case of a person who is discharged at his own request.
My lord, if my lord, at own request, my lord, he discharged, my lord, he cannot entitle, my lord.
Out here is your own request.
No, I am not on request. I am entitled, my lord, superannuation, my lord. I am retired, my lord.
I'm
I'm-
just, if your lordship will just,
I am
Who is
not.
eligible for yes. Just a minute, I will give you a chance.
My-
Please sit down.
lordship, I am taken by surprise. Is that this I was not talked about this. If there is an amendment, should I look at instructions?
Okay, yeah. No, we'll have to look at this very carefully. Because it says, except in the case of who is eligible for special pension or gratuity under this regulation. Except in the
Whether,
case.
because lordship will see, this is
This is
not the first pension.
this no.
This is
Besides
the
that,
second pension that he is getting.
what is the first pension even under
First
this?
pension is lordship, the period for which he is working.
No, that I agree. No, as a normal thing, in normal service, how much would be, how much is the qualifying service for pension?
15 years. my lord.
Whether this will be applicable for the second pension,
Just
I
look-
just
just
get a
look, yeah.
clarification.
My lord. My lord, kindly come to the page number, my lord. 61, my lord. This issue already settled, my lord.
61 now?
61, my lord, of the, my lord, read petition, my lord.
61 or it could be. Yes,
My lord, subject, my lord.
yes,
Condon of deficiency service for grant of second service pension in respect of DSC, my lord.
yes.
My lord, I am, my lord, this is my case, my lord, I am DSC, my lord. My lord, kindly, my lord, come to the column 2, my lord, paragraph
Yes.
2, my lord. Representation of ex-service who have been granted service in pension from army side and re-employed in DSC are received for condonation of deficiency in service for second pension from DSC. The matter has been examined and decided, and condonation of deficiency in qualification service is to be accorded on merit, and in the deserving case of make individual eligible at least one service pension.
It is only
Condon of deficiency in qualification service for granting of second pension in respect of DSC personnel has no merit. My lord, now come to the, my lord, page number.
no, that says
Page-
lordship,
page.
at least the person should be
My lord.
getting one pension, and if he's for some reason not getting the first pension.
My lord, I am
that will be-
clarify, my lord. Kindly come to the page number, my lord, 22, my lord. 22 of the judgment, my lord.
Yes,
22 of the writ petition, my lord. In Bhavani Devi Supra, my lord, it was held that the provision for condolation of shortfall in service under regulation 125. My lord, earlier this rule is 125, my lord, now is 44, my lord. Of pension regulation of army, for the army 1961 part 1 are equally applicable to the armed force servicing in DSC, making the eligible for grant of second service pension against the order in so and so, my lord, X Mohan Chopra, granting condole of shortfall of DSC, my lord, subsequent to the issue of, my lord, government memorandum, my lord. This memorandum, my lord, which, my lord, page number 61 is the memorandum, my lord, here, my lord. The respondent had approached the Honorable Supreme Court by filing, my lord, civil appeal, my lord, so and so, my lord, which was dismissed by order that so and so, my lord, and thus matter has attained finality, my lord. This, my lord, notification, my lord, already set aside by the, my lord, Supreme Court, my lord. Now, my lord, this already settled, my lord. I am entitled, my lord, and my lord, this rule is also applicable in the DSC, my lord. DSC second pension, my lord. This is the case. That's why, my lord, trial court, my lord, pass this order, my lord, the reasonable order, my lord. Now, my lord, how, my lord, from the, my lord, starting point, my lord,
just
they
a
have
minute, just a
started.
minute, just let me read this judgment. So basically, in this Navy case also, the 6 months condonation allowed had been extended to 1 year. So you'll have to see this 44.
I will take some
Because
clarification on
he has
this.
completed 14 years.
He has completed
14
14 years
years.
and.
Yeah,
1 month
14
sentence.
years. So if we allowed 1 year,
That,
then
that,
that
no,
case.
if he gets, that's not a problem.
So,
I
so
just
let him
get
obtain
a
instruction.
clarification.
When?
Monday, no, sure.
Right. Mr. R.K.D. Chaudhary, the learned counsel for the appellant, submits that he will obtain instructions with regard to regulation 44 of the
Yes, sir.
pension regulations of the army, part 1, bracket 2008, which came into effect from 1/7/2008. Pusta. The said regulation 44 states as follows, page 25. Okay. Take this. Next para. The petitioner has apparently, the respondent has apparently served for 14 years, 1 month.
2 months,
Huh?
1 month, 28 days.
For
28.
1 month to 14 years, 1 month, 28 days. And in terms of regulation 125,
125.
125, there can be a condemnation of the qualifying service up to 6 months in terms of 125, and in terms of regulation 44, it has been extended up to, it has allegedly been extended up to 1. This is a matter on Monday to enable Ms. R.K.D. Chaudhary to obtain instructions in the matter. The matter pertains to payment of second pension, just like that.
Obliged.
Lordship, in this case, the relevant is to file an affidavit. We have filed that affidavit on Friday, Lordship, but there is some defective issues are there. Let me rectify the Lordship
Okay, you filed it on Friday.
on Friday.
Mr. B. Chakrabarti, learned counsel for the
Railways,
railways, submits that the affidavit filed by him on
Friday, last Friday.
Friday is what?
21.
Huh?
21.
21/11/2025 has some defects which he would like to correct. He accordingly prays that the matter may be listed after.
Any date, Lordship, one next week.
List the matter on 8 December.
Monday.
Lordship, I'm for the impeding applicants. We have effected service on all the respondents in the and by.
You were supposed to take steps for service of notice.
Yes, sir.
Have you submitted the Talabana?
Yes, sir, Lord.
Where?
It's a
When did you do it?
1911.
1911.
Yes.
You took steps.
Yes, sir.
Okay. So, Mr.
S. Sonowal.
S.
Sonowal.
Sonowal, learned counsel for the applicant, submits that steps have been taken on 19/11/2025 for service of notice upon the respondents in terms of the order dated 18/11/2024. 18/11/2024. After 1 year,
Your
you have
Lordship,
taken steps.
after that, there is one more order.
But you never took steps.
We had taken initially steps on 16, 17, and 18. After that, 1 to 15, 19, and 20 were.
No, there's nothing. In the office notes, there's nothing showing that you have taken any step. Okay, right. In view of the above, list the matter. After vacation, there's no stay order, no?
No.
This is the matter after vacation.
Obliged.
The state of Assam has floated a tender of 320 crores for modification of the zoo. Already work has been allotted. So our part is done, my lords.
What about Nagaland?
Lordship, Nagaland is housing two species of exotic birds.
Only?
Yes, but like for that, like I mean, so we have already
Yes, madam.
submitted a revised this thing master layout plan before the Central Zoo Authority of India, which is yet to be like.
Only for two species of birds?
Yes, your lordship. Exotic.
Exotic.
Yes, your lordship.
How many birds is that? Two species? Okay.
Only two emus.
Two emus?
Yes, your lordship.
That is one species. That's not two species.
No, but like
There are one bird. There are two birds of one species.
I know, like
Lordship, in the reply of their RTI, they have categorically mentioned that they have many animals of exotic species in their captivity in the zoos. So regarding those animals, the minimum guidelines of they have specifically mentioned that these animals must be placed in a category in a enclosed.
Well, now they're saying that they've got only one species of bird. One bird species.
Their lordship kindly come to annexure 4, page number 39.
what to reply nine?
Who's the president referring?
Can't reply. I think he's talking about RTI.
If you come to page number 41, there they have provided a detailed list of all the endangered species animals.
Where is this zoo that you have?
In
Madam?
Dimapur, Rangapahar.
In Rangapahar?
Yes, your lordship.
Metsi Fema.
No, it won't be Magic Temple.
Okay.
I don't know how to say it.
Rangapahar. Okay, this is there. So this page 41, out here is quite a few animals.
Yes.
Lordship, it is, I'm not denying it, but like as per my instruction, they said they're housing only two distinct exotic birds.
Emu.
Yes, your lordship.
EMU.
EMU.
Lordship,
Three,
they can just say that they don't have.
How do you know birds don't live forever? Animals don't live forever. Huh?
The mammals and the animals, they have Himalayan black bear, they have the common jackal, they have the Indian wolf, they have all these animals.
This is 25. This is 23.
This is 23 December at 25 November. So I don't know. You'll have to clarify, madam.
Lordship, this is 23. The lease is of 23. The instruction I received is of 25.
So what happened within these 2 years?
Lordship may grant me some time, like I'll confirm. Mauritius has been good. It was nice. Not good.
Okay, right.
As well, when it comes to the state of Assam, they have to mention that they will construct a.
No, my lords.
According
The
to the.
tender document covers everything. 320 rupees.
So where is that?
No, it's not.
Tender document, where is that?
So it's
You file an affidavit.
Yes.
Yes.
It's a very voluminous document.
Whatever, you file it. Whether it's voluminous or not.
Yes, and they have to mention that they will comply with these guidelines. The zoo has to be constructed according to the guidelines. The amount of money is not the issue.
Under the rules, you mean?
Yes. Minimum dimensions of.
Okay, right. Mr. Yes, you are appearing. You sure?
That is my instruction.
No, no, yeah, there's a number of them in the forest at least.
Lordship, the forest is.
So
Perhaps they
no,
don't need zoos because their area is more covered, and forest cover is more.
they've got open zoos, no?
Yes.
Open zoo. So,
Each day, my lord, each passing day, every 2 months or 3 months, new animal is discovered. Either be a frog, either be a bull, new animals are being discovered. Every passing 2-3.
Unexplored.
you won't know the population, the census. You don't conduct any census of the animals, I think, no?
Lordship,
Whether the population going up or down, no idea.
I don't have any idea. Lordship, it's forest department should have been doing the lordship.
Okay. So they've got no zoos in Arunachal.
Last time I.
So your case is, huh?
No, actually, I went to Arunachal and I remember seeing a zoo.
You know, did you go inside the zoo?
I did not go inside.
There might be a zoo without any animals inside. There can be a prison without prisoners. How many jails are there?
I think. Zoo is there.
Zoo is there, Lordship. It's
Then-
another, it's small.
How many animals are there?
Lordship, that instruction also not there with me, Lordship. What they have instructed me is that there is no exotic animal in that zoo,
Let
Lordship.
them come with an affidavit. so
Lordship, that I
can
shall do,
verify
Lordship.
After it comes on record. Because now, right now, they are only saying,
No, what do you want to bring out in your PIL? You mean to say that they're not having enough space?
yes, non-compliance of the.
How do you know they're not having enough space for Arunachal? Why do you want to have a roving inquiry?
No, not inquiry.
Have you seen in the zoo one animal till now?
No, I'm saying about the affidavit. They have not.
No, forget about affidavit. You cannot just go and say that I want to know about America. Please give me American government. Give me an affidavit of what your lifestyle is, what your population is. You have got to say something with regard to Assam, with regard to any of the state. You have got to say that when I went there, I saw that there were 20 tigers in one room like as big as this. Something like that.
Yeah, with Assam, in this case is crystal clear.
With Arunachal, why do you want to have a
With Nagaland
roving
also
inquiry?
it's clear.
How does it benefit you? Or
With
the animals that are not existent?
With Arunachal, he has come with this fact today. So.
You have to first, you cannot just ask the court to have a roving inquiry.
No, not
Just because you want to do good, you are an animal lover. They are animal lovers, they have got the entire open air jail or open air zoo. Whole of Nagaland, whole of Arunachal may be a zoo.
Okay, even if I don't press for Arunachal, but the case for Nagaland and Assam is clearly established.
Arunachal, why should you pray? Unless you go and see that they are not living as per the requirements of the rule and the act. Nagaland is okay. Now there's a discrepancy between the statement made and the document. So that's fine. No, madam, they would be a busy. They have not even gone.
In case of Assam, it's dynamic changes because lot of wildlife offenders are there. We seize a lot of them. So it's not sometimes it's not too uniform that everyone should have that kind of structure. Because if you go to the zoo, you'll see roaming. Some big parts are roaming and walking around here. But sometimes it's not possible. Some exotic species we seize them from border of Silchar. Exotic species they are being smuggled. So sometimes it's not possible also.
Probably from my state.
Why not?
Silchar will be from my state.
So,
like the 4 kangaroos
yes,
that were seen hopping around in Siliguri.
Recently, we got a big consignment of
That is kind of monkey, not found here. It's whole monkey. It is a quarter has been converted to his for its confined. It's not that uniform. It keeps on changing.
Yes, but the minimum accommodation capacity has to be there.
Ready-made for you then.
Okay, I don't know. But a big problem, zoos are big problem. You need a lot of money. You need a lot of people to look after zoos. And especially these exotic animals.
The state is responsible for the maintenance.
But if the smugglers bring it in, and which are not, they're not of the local species, then what to do?
No, right now we have to follow the mandate of the guidelines. These are provided by the experts. So we have to follow their advice.
So the Assam is trying to do that now.
But exigency is there. New animal is what you have to bring it.
We'll give you time.
I think it's
Right.
Yes, let them file a detailed application.
We'll bring it.
So you're not pressing for Arunachal.
If
Naturally.
you saying that there is nothing there, then I will go by his words.
There is no exotic animal, Lordship. That is submission, Lordship.
But is this petition only for exotic? It's not for exotic, it's for all
Lordship,
kinds of animals.
Lordship's prayer says that respondents to comply comprehensively and strictly on every parameter of the guideline on minimum dimension of enclosures for housing exotic animals of different species issued by the Central Zoo Authority.
So whichever animals are covered within these guidelines, my case only lies there.
Page 9 of his PI,
You
Lordship.
cannot you cannot ask for a roving inquiry.
Not roving, I'm asking for compliance.
Arunachal?
No, I'm not pressing for Arunachal.
Okay, right. Heard the counsel for the petition who submit that review of the submission made by Mr.
Lordship A. Chandran, Lordship.
A. Chandra, learned counsel for the state of Arunachal. He is not pressing his case. Who submits that there is no animal in the Arunachal Zoo.
Exotic animal.
There's no exotic animal
Lordship.
in the Itanagar Zoo.
Lordship, it's not zoo, Lordship, it's biological park, Lordship.
In the biological park
Lordship.
in Itanagar.
Lordship.
He is not pressing this case against the state of Arunachal. Next, Mr. R.R. Gogoi, D. Gogoi, learned counsel for the Forest Department submits that a tender has been awarded, a tender and work has been awarded to a contractor. For what?
For modification of zoo.
For modification of the zoo. So that the animals are housed as far as possible in terms of the recognition of Zoo Rules 2009. Correct? And the act and the concerned act. Mr. D. Gogoi has submitted an affidavit with regard to the tender and the contract awarded in the contract. Next, Miss Learned, Additional AG, Nagaland, submits that she will obtain instruction with regard to, where is that? With regard to page
41.
With regard to the captive inventory of animals and birds as on 31/12/2023, which is a part of the writ petition. Writ
Yeah.
petition.
It should be a PI.
PIL, Lordship.
Huh?
PIL.
Which is regard to PIL at page 41. Juxtaposed with the instruction given to her recently that there are only two emus, EMUS, in the zoo located at Rangapathat. How do you spell?
Pahar.
Rangapahar. RANGAPAHAR. Rangapahar.
It's Nagaland Zoological Park, Rangapahar.
Nagaland Zoological Park, Rangapahar. List the matter. On 27 January.
Much obliged.
January 27.
May I please your lordship? Lordship, regarding item number 8, I have a small prayer. And this matter be listed at, if it's at 2.
No problem at all.
Come up.
Huh?
Fix it to item 8.
The short point involved is with regard to page
Of the judgment, Miller.
of the advertisement.
54, yes, advertisement.
That number 5. second
Yes.
term, 5.
Minimum 10 research paper.
Yes, a minimum of 10 research publication peer review. Now come to page 465.
Yes, Miller.
Come to A.
Regarding research paper submitted by Pratibha Patwari, 10 so of this only one paper has been published in UGC so. Another 4 papers neither. No, this is wrong, Millard. Kindly, why I'm saying so? Millard, first Lordship will kindly see the selection committee approved my name. Then it was forwarded to the director. In the directorate, Millard, what they did, applying that preference criteria in the advertisement, appointment was given to him. Then
You're the one with the higher mark.
yes. Then, Millard, what happened? I challenged the action of the authority in
He's
appointing.
he's got the second highest mark.
Yes.
And he's the BTR.
Yes.
Ah.
Is the BTR preference part.
Ah.
Two candidates were.
Yes. No, amongst others, they were selected. They were in the 1 and 2. Then, my lord, in the writ petition filed by me, only point he pleaded was that as a resident of BTR area, he is entitled to preference. He never raised all this plea. He could have raised. Then, as a counter blast, my lord, he filed his writ petition where he says that out of the 10 research paper, we are not meeting the requirement. Now, kindly come to his writ petition. Now, how can he improve his case? Please come to his writ petition, my lord, at page number 97. It starts at 91. Now he cannot come up with a new case. This was his case, Miller, before the learned single judge.
In 97.
Yes, para 15.
That is his writ petition.
His writ petition. That the petitioner is, as a lordship got it,
Yes.
Miller? Yeah. That the petitioner respectfully states that respondent number 8 cannot come within the zone of selection for the post of principal of Goreshwar College in pursuant to advertisement dated 1/10/21, in as much as she is not qualified to participate in the selection process, as there is a lacking of minimum 10 research publication as per paragraph 5 of the advertisement on the part of the respondent number 8. Further, the document will show that out of 10 research papers, only 6 papers may fulfill UGC regulation and rest 4 does not fulfill the UGC regulation, as it was not published in peer-reviewed or UGC listed journal as per provisions of UGC guidelines, and therefore her selection is expressly illegal and liable to be set aside and quashed. So, my lord, my learned friend's client's specific case was, out of the 10 research papers, 6 are okay. In respect of 4, it does not meet the requirement of publishing in peer-reviewed journal. This was his case, my lord. Now, my lord, we'll kindly come to, I'm not even placing my case, my lord. Please come to the affidavit in opposition filed by my lord, Borolan University, my lord, at page 481. To be precise, at para 15, page 491.
15 and 16. Deponent submits that in the absence of the records of the selection, I'm sorry, Milan, page 491,
Yes,
para 15 and 16.
yes.
That the deponent submits that in absence of records of selection process in the present matter, the names of journals submitted by respondent number 7 has been derived from the list of publication compiled by UGC in its counter affidavit in the present writ petition. Out of the 10 research publications submitted by respondent number 8, the petitioner disputes 4 research publications as not fulfilling the minimum criteria prescribed by UGC Regulation 18 on the ground that these were not published in peer-reviewed or UGC-listed journal. As the petitioner admits to the eligibility of 6 of the research publication of respondent number 8, as is seen in Annexure 12 appended to this writ petition, deponent would thus like to confine its comment on 4 research publication of respondent number 8, which are in dispute herein. The deponent, however, begs to seek leave of this honorable court to submit further reply should such a need arise during the proceedings of the present writ petition. Having made the submission as above, deponent begs to submit that the following disputed 4 research publication of respondent number 8 have been published in journal that are peer-reviewed, referred journal, and research scores. These publications were allotted in accordance with the criteria prescribed in Appendix 2, Table 2 of the UGC Regulation 2018 after due verification. So, my lord, what remains? Now, kindly come to the, my lord. Before that, my lord, before I come to the learned single judge's order, if your lordship would kindly take my affidavit which was filed before the learned single judge, my lord.
Just a minute.
Yes.
When was the judgment and order passed?
My lord, judgment and order was passed on 3/9/25. Now, my lord will kindly come to page number 193, my affidavit in opposition before the learned single judge. I'll have your lordship's kind attention to page number 197. Paragraph 8. That the statements made in paragraph 10 of the writ petition are incorrect, motivated, and baseless, and the same is stoutly denied by this deponent and states that she has due qualification and eligibility for the post of principal as she fulfills the condition number 5 of the advertisement dated so and so. Deponent has got 10 of her research paper published in peer review or UGC listed journal, which are clearly mentioned in part B at page 3 and 4 of her application form dated 13/1/23. And those 10 research paper will cover page of journals have been submitted along with the application form, which is mentioned at serial number 20 of the contents from page 37 to 155. The cover page of the journal clearly shows whether the journal is peer-reviewed or UGC listed and its impact factor. The total research score of the deponent comes to 434.5 and research score from 10 research paper only comes to 176. As 6 of the journals were published, her research papers have impact factor between 5 to 10, which gives 25 points for each of the said research paper. As such, deponent fulfills all the mandatory eligibility requirement of regulation under so and so for participation in this election process. Well, this writ petition was a counter blast. When I said, my lord, that my selection was improperly, my lord, sought to be denied on the ground that he belongs to BTR, then, my lord, he came up with this writ petition. Now, kindly see how the learned single judge deals with it, my lord. That your lordships will get at page number 523. Please come to para 19, my lord, at page 523. As already stated earlier, dispute has been raised in respect of contention provided under clause 5 and clause 10 of the advertisement dated so and so. Clause 5 of the advertisement provides that the applicant for the post in question should have a minimum 10 research publication in peer-reviewed or UGC listed journal and a minimum of 110 research score as per Appendix 2 at so and so. Clause 10 of the advertisement provides that preference shall be given to the candidate belonging to BTR. The selection for the post of principal Gorosar College was made in terms of the relevant provisions of the Assam College Employees Provision Rules 210. Constituted selection committee conducted the interview of the eligible candidates for the post in question on 6/4/23 and allotted 427 marks to the writ petitioner of so and so, that is the Milord respondent whom we represent, while 400.58 marks were marks to the petitioner in WPC whom my learned friend represent. Accordingly, petitioner in WPC was selected for appointment against the post in question, and the result of the selection committee was sent to the governing body of the college for approval and necessary action. Governing body of the college held its meeting on 16/4/23 and authorized the principal in charge, president of the governing body, to submit the proposal to the director for necessary action. It was observed that the petitioner in WPC had secured the first position, while petitioner in WPC secured the second position and is a permanent resident of BTR. Thereafter, by impugn order dated so and so, the petitioner in WPC who secured the second position was appointed as principal of the Gorosar College, apparently on the ground that he belongs to BTR, and therefore preference was given in terms of clause 10 of the advertisement. So, Milord, public order publicly made has to be construed in the context in which it is made. He was appointed because he was given preference in terms of clause 10 of the advertisement. Now, para 20. This stand taken is common as can be seen in the affidavit filed by the governing body, the affidavit of the petitioner in WPC and in the affidavit of the director. However, the preference for candidate belonging to BTR can be invoked when parties concerned are at par, in other words, in other aspects stipulated by the advertisement. Apex court in so-and-so held preference in the context of such competitive scheme could only be made when all other things are qualitatively and quantitatively equal. This finding was also adopted by the Apex Court in subsequent decision of so-and-so, so-and-so, so-and-so. Now, para 21 is important, Milord. It may be seen that petitioner in WPC 598 of 24 has questioned the eligible, that is the my learned friend's client, eligibility of the petitioner in so-and-so to be considered for appointment to the post in question on the ground that she did not fulfill the criteria as provided in clause 5 of the advertisement, which is in terms of the UGC regulation of 2018. It may be seen that although the said petitioner was arrayed as respondent number 7 in WPC number 9, this is important, but no objection was made in this regard except for stating that he was given the preference and appointed as principal of the college in terms of clause 10 of the advertisement. So there was a litigation between the parties where this point was not raised. It may be further be seen that petitioner in 598 of 24 was arrayed as respondent number 7 in WPC so-and-so, and he received the notice issued to him registered post with AD and returned AD card. As already stated, no objection in respect of the petitioner in WPC for not having fulfilled criteria stipulated in clause 5 of the advertisement has been raised, and it was only on 6/2/24 that he raised the issue of by filing WPC number so-and-so. The petitioner in WPC being arrayed as respondent number 8 by the petitioner in so-and-so in her counter affidavit contended she duly fulfilled part A and part B of the application form containing total 9 pages along with all the required documents. So she also contended she fulfills condition number 5 of the advertisement. She secured 10 marks for her 10 research paper published in the peer review or UGC listed journal. The respondent, Bodoland University, in their counter affidavit has stated that out of the 10 research publications submitted by respondent number 8, The petitioner in WPC has disputed 4 research publications for non-fulfillment of the minimum criteria prescribed by UGC regulation of 2018 on the ground that these were not published in peer-reviewed or UGC listed journal. Therefore, university confined its response only to 4 research publications. Paragraph 16 of the affidavit may be extracted. I have already read this from the affidavit, my lord. Therefore, my lord will kindly come to para 23. Therefore, having regard to the matter in which the post of the principal has been processed to be filled up in accordance with the Assam College Employees Provincialized Rule 2010 and a requirement in terms of UGC regulation, the dispute raised by the petitioner in WPC number 59/24 cannot be accepted, and it also appears to be an afterthought. The respondent authorities concerned could have appointed the petitioner in WPC number so-and-so, despite having found him to be in second position and securing lesser mark than petitioner in WPC on the ground that preference should be given as per clause 10 of the advertisement. Said preference, as already stated earlier, can only be applied in case where all the other things are qualitatively and quantitatively equal. In the result, the order dated so-and-so, the appointment of the petitioner as principal Goreshwar is hereby set aside. My lord, summarize my argument, my lord. In the writ petition filed by me, questioning his selection, neither the appellant herein, my lord, nor the governing body of college, nor anybody raised any issue about my, my lord, ineligibility on account of not fulfilling clause 5 of the advertisement. Now, it is an absolute afterthought, my lord. In fact, if we go by the pleadings in the writ petition in para 15 of the appellant himself, he said that out of 10, 4 are not peer reviewed. The Boroland University filed an affidavit clarifying the issue. So what remains, my lord? And in spite of the fact that there is no stay order, my lord, he is still continuing till today.
This page 465.
Yes, my lord.
This is a reconstituted committee.
My lord, end of the day, my lord, end of the day, it was the selection committee who has done it. Selection committee records will reveal, my lord, whether I have got or not.
So the issue is basically, he has, okay, maybe question 4.
Yes.
But the fact remains is the issue of whether you are eligible. So let them take a call on that, whether you are eligible. If you are eligible, well and good. If you are not eligible, then it has to go. Maybe an afterthought, but still, it is an issue that has to be decided.
No, my lord, my humble submission is very simple. There is a concept called constructive res judicata. Is he not barred, my lord? Would your lordships entertain a litigation which has the potential of racking up a dead issue?
There's no bar. I don't think there's a bar. That's why it has come to the single bench. Now it's coming here. It's a continuation of an issue.
No, my lord, what I'm saying is, no, my lord, I'm on a legal principle. My submission is, you had the occasion to raise this point, that the selection, why I should not be selected. He could have said, number 1, not only I'm entitled to preference, number 2, he is also not entitled for the simple reason that she does not fulfill this criteria. Is it not expected of a client, my lord? Is it not expected of a litigant?
There is.
No, my lord, then what meaning we give to public policy? What meaning we give to, my lord, res judicata principle? What meaning we give to constructive res judicata principle? Then these are all dead letters. Kindly see, my lord. End of the day, a overzealous litigant is trying to invoke the extraordinary jurisdiction of this court by an subterfuge.
If you are
Will your lordships encourage that?
No, if you are eligible,
yes,
that will be clarified by the authorities. That's all.
No, authority has already clarified.
Let them have another.
No, my lord, my humble submission is, before passing that order, lordship will kindly have a look at the records. Let me, lord, the selection authority produce the record whether my journals are peer reviewed or not. No, let lordship will have a, satisfaction, my lord. Why it should go to the authority? Why will lordship give a long handle to the authority? We do not know how they will behave. My submission is very simple. I have asserted on oath, nobody has denied that. Who has denied my statement in para 9 of my 15 of my affidavit in opposition? Nobody has denied that statement, neither he. It cannot be so mechanical, my lord. My humble submission is, your lordships will call for the records. If your lordship finds these are not peer reviewed, then lordship take a call. But not lordship will not relegate the matter to them. My lord, selection is over, everything is over, my name is recommended. Now at this stage, my lord, they're coming up with some new pleas. In fact, these pleas barred by constructive res judicata. So my humble submission is, my lord, let the records be produced by the selection. Yeah. Now, if your lordship should kindly come to page number 216 onwards, my lord, all my publications are there. Kindly see, my lord. Page number 216 onwards. And I have given the page number. I have given each and every minute details of my application form in my affidavit. Who has denied that? Kindly see, my lord. And my lord, the expert, Boroland University says it is okay. Who is the petitioner appellant to say dispute that, my lord? Kindly see page 216, a multidisciplinary international peer-reviewed reference journal. Then please come to 217. 218, 219, 220, 221, 222, 223, 224, 225, 226, 227. Lord, my statement in para 197, who has disputed and denied this? And I have given, my lord, in which part, in which page, my the materials are there of the publication. So therefore, my humble submission is, lordship will call for the records from the selecting authority. From there, if your lordship is satisfied that no, there is a scope for some rethinking, then lordship will pass that order. এখনো reply file করেছে নাকি? না সিহঁতি?
Yes, anything else?
That's all. My only submission is, Miller, there is no reply to that.
My lord, your lordships have seen the revaluation committee's report at 465. This has not come out from the thin air. This is a part of the affidavit filed by the BTC. That affidavit starts at page 459. And may I draw your lordship's attention to paragraph 12 of that affidavit?
Yes.
That is at 462. May I read that?
Yes.
That as regards the statement made in paragraph 13 of the instant writ petition, the deponent begs to state that it is a matter of record as regards to the publication of research papers by the petitioner as well as the respondent number 8 in the peer-reviewed or UGC-listed journals, and therefore in this context, the BTC constituted a committee by BTC notification, memo number such and such, dated 4/4/2024, for re-verification of research papers published in journals submitted by the petitioner and the respondent number 8 for the post of Principal Bhubaneswar College. Thereafter, a meeting was conducted on 1/6/2024, and accordingly minutes was drawn stating that the respondent number 8 has submitted 10 research papers, and out of this only one paper has been published in the UGC care listed journal and is valid for consideration. Another 4 papers are neither published in indexed nor in peer-reviewed journal and hence may be rejected. So, my lord, there, on that basis, my lord, this has been, my lord, that has been annexed by in the affidavit of the BTC. This has not been considered at all by the, my lord, honorable single judge. Only, my lord, on the simple ground that I have come as an afterthought. In fact, my lord, after my appointment was challenged, my lord, on the basis of the RTI, my lord, I obtained some, my lord, documents. And my lord, this affidavit, my lord, there has not been any reply by the, my lord, the respondent number 1 against this. And this report, my lord, stands as on today. There is no challenge to this order. This, my lord, review committee findings. Therefore, my lord, the respondent number 1 is not eligible. My lord, in the event your lordship does not interfere in this order, my lord, this will give a stamp of approval of the, my lord, the respondent not being eligible, still be holding the post of principal.
Okay. Anybody else?
Milord, my only one thing, Milord, there is no selection in favor of the petitioner, appellant. How come he is holding the post? Nobody has selected him. Now, this aspect is before your lordships today.
I am the selected number 2, my lord. I am in serial number 2. If one goes.
Appointment order?
Yes.
Appointment lord letter at page 59.
Okay, right.
Milord, my only submission, one second. My only submission is, Milord, the original selection committee didn't find any fault. Secondly, Milord, it was never the stand of anybody that I am lacking in terms of clause 5 of the advertisement. Now, only stand taken was he is a permanent resident of BTR, therefore he is entitled to preference. On that point, Milord, your lordship also as a learned single judge of this honorable court has rendered a judgment saying nothing, there is nothing like preference. Question of preference will come when other things are equal. Same notification lordship has interfered with.
He's not pressing that point.
No, he is not pressing. Not saying. Secondly, my lord, regarding this point, my humble submission is, my lord, lordship will kindly call for the records. And lordship will try to satisfy yourselves, my lord, whether what he is saying is right or I am saying is right. Now, my lord, an expert has already undertaken the job. Now, my lord, what is the sanctity of this committee, my lord? And admittedly, my lord, the BTC authority was trying to help the appellant. That's why I am so, my lord, conscious of the fact that if the matter goes back on remand, they will take a U-turn, my lord. I'll have to again come. That is why I am saying, my lord, lordship will be satisfied. Please call for the records and try to find out what I am saying is correct or wrong. Now, my lord, if the documents which I have annexed with my application is a peer-reviewed publication, then it will be self-evident. And there is no requirement of any expert for that. In which case, my lord, my application would have been rejected at the first go. It's not that, my lord, my uncle and nephew sitting in the selection committee, they have selected me. On the contrary, he had people who was backing him up because despite securing lesser marks, he was sought to be appointed. Why? On the plea of giving preference when that plea of preference is not even available. That's why my humble submission is, my lord, please call for the records from the selection authority. And that will be clear. If your lordship is satisfied, yes, these are not peer-reviewed documents, and I have given my page number, part number, everything. That will reveal. Thereafter, my lord, it is not a rocket science that somebody, experts has to come and apply their mind to this. If it is peer-reviewed, it is peer-reviewed. If it is not, I have annexed in my writ petition from page 216. That is the situation, my lord. And my lord, I have worked hard for this, my lord.
Was the chairman of the election committee, I had to the rule one. All the records have been transferred after the election. To the governing body, it is lying with the.
And Vice Chancellor of the university was the head of the selection committee.
So who conducted the selection?
The selection committee, which was headed by the Vice Chancellor of the university,
Which university?
Boroland University.
And this, who are the members of this committee at page 465?
Different.
They're different experts, my lord, in the affidavit.
Six, my lord. That's the first regard to marking and
Yes.
the person of the selection commission.
First one.
Who is this Margati Burman? Page 465.
465, my lord, altogether different.
Earlier, Milord. And Milord, at page 465, the chairman has not signed the proceedings. Kindly see, Milord. Page 465, Amarjyoti Burman has not signed the proceedings.
No, who made up the selection committee?
That's what, Milord.
Well, that has been stated in paragraph, my lord, 12, but then it's not very clear, my lord.
Ah.
We have to obtain instruction.
Why that situation arose?
Situation
Was it necessary?
No, the issue is this. The issue is according.
Thank you. This was the original selection committee,
Wait.
213. Vice Chancellor, Boroland University, President and GB member, then Professor Jagat Sorgiari, expert, Keshav Bosumundari, government nominee, then Milord Prosen Doimari, expert, Professor Indira Boro, VC nominee, and Professor Sujit Deka, expert. There were 3 experts. So 3 experts has taken a view, Milord.
My lord, BTC will be, my lord, who has filed this affidavit. They would be in a position to say, my lord, who are these persons who have been, my lord,
Exactly,
part of the, my lord, that
No,
report.
you see, the issue is this. They are of the view that eligibility criteria can be looked into at any time.
My lord.
So we'll have to go by the eligibility criteria. Only thing is that he was found to be eligible. Now suddenly, by way of this committee that has been constituted for re-verification, he has been found not eligible. And we find that the earlier selection committee is not a part of this subsequent selection committee, this verification committee. So we are of the tentative view that the earlier selection committee should relook the eligibility criteria of the respondent in terms of clause, and that will hold the field.
In the light of the finding of that expert committee, my lord.
No.
That may also be, my lord, they are one of the documents they can consider. My lord.
No, they can look into it. They will say that with clean slate. Keeping this in view, they'll keep this in view also. How does it?
Yes, my lord.
The earlier committee will look into it.
Yes, the earlier committee, the earlier selection committee.
Milord, I am reiterating my argument, Milord. Would your lordship?
No, we
No,
won't.
what I am saying is, Milord, it is not a very big deal. Kindly bear with me, Milord. It is not a big deal. All that you have to find out is whether it is listed in a peer review journal. That's all. If that is evident, my lord, self-evident, that will be self-evident. That's why I'm saying, Milord, please don't allow this exercise to go, Milord, because it will linger. Milord, that will cleanse the issue.
I will not have any objection if the, my lord, earlier selection committee, my lord, reconsiders it. I will not have any objection to that also, my lord.
Where is the question of reconsideration?
Will this court be able to decide if we call for the records?
Yes,
No, let me ask him. You have
Yes.
already said your piece.
my submission is that, my lord,
No, according to you,
my lord, according to me, my
you
lord,
will be able to come to a finding as to whether
perhaps, my lord,
she fulfills clause 5 or not.
my lord, in my humble submission, my lord, perhaps it will be more prudent to, my lord, leave it to an expert committee.
No, the expert has already said.
We,
No, there's nothing clear.
These journals which are published, specifically mentioned in the journals, whether it is a peer reviewed journal
Yes.
or not, or whether it is a UGC listed journal. or not. On the cover page itself, it is mentioned whether it is peer reviewed or UGC listed. So mere perusal of the.
We'll make it clear.
Yes.
Will make it clear.
my lord.
That's why I'm saying is-
UGC is a party to the proceeding, my lord. UGC has not come up with, my lord, any specific, my lord, stand.
Doesn't matter. You're not countering any of her submissions.
No, my lord.
UGC has already filed that.
Yes.
And in that particular affidavit, all the publications of the appellant as well as the respondent number 1, they have categorically mentioned with regard to the 1010 papers, whether it is UGC listed or not.
And according to you,
The Lordship, according to that, so far as the appellant is concerned, UGC approved is 5.
Five.
Only 5.
Ah.
5 are UGC listed, and so far as respondent number 1 is concerned, only one article has been published by UGC care listed. But if you go to the eligibility criteria as per the UGC regulations, it clearly specifies that it is not necessary for the number of articles to be listed in a UGC care list. It can either be peer reviewed journal or UGC care.
correct. Either.
Either.
How much has the respondent number 1 got?
Let us see their affidavit.
The record speaks about peer list. So far as peer review is concerned, that will have to be analyzed after.
So it is either or.
Yes, sir.
So you have not clarified.
Yes,
Yes.
that is
But
what I said.
according to you, if we call for the records, it can be ascertained by us.
Yes.
We have the expertise to do that.
Yes.
We are very skeptical. But if you believe in us, we'll do it.
Mentioned.
I would believe, my lord. I would believe, my lord, even if your lordship doesn't send it back to some experts, my lord, even then your lordship's consideration is enough for me.
Okay, if that is the case, then we'll record a submission and then we'll list it. Who is for the university? Who is who is for the BTC? Yes, Mr. Nguyen, can you bring it? What time will you require?
Governing body, my lord.
Can you bring the records pertaining to clause 5? That's all. It'll be one.
Yes,
It won't be so thick.
yes, my lord. 10 days time they'll be giving so that I can correspondently bring the record from them.
You can just tell them over the phone and they'll come rushing. We can list it next week.
Next.
Yes.
Be either on 5th or any data. 5 or 8.
Okay, we'll do it on why?
Lordship, I have some personal difficulty. I have applied for leave from
Okay, so 5. Huh?
5 is 5.
Yes.
5 we can do it on 5. Okay,
My
we'll
lord,
just record.
my prayer would be, my lord, till that time your lordship will see the order.
Be protect. Sure.
Plus, he's already, just let there be no order, my lord, because lordship has not granted.
No contempt then.
Yes. No, my lord, we are not going to initiate any contempt.
No, my lord, the BTC council has already submitted, my lord. They have taken the decision to, my lord, comply with the single judge's order, my lord.
No,
That's true.
No, my lord will kindly bear with me, my lord. What is his right after his judgment has been set aside? His selection has been set aside.
it before your lordship, my lord.
There is no stay order.
No, that's
I'm
what
praying
he-
for a
that's
stay
what
order.
he's praying for.
I'm praying for a stay order.
Praying for.
No, lordship will not. This is not a case where lordship will grant a stay order.
We are disposing it on 5th. So,
No. I know lordship will dispose, but is it a case where lordship will grant a stay order?
Why not? Why not?
From May 2023, my lord, I am working, my lord, till date. That is not in dispute.
Right. Okay, right. Heard Mr. M.K. Chowdhury, learned senior counsel for the appellant, assisted by Mr. D. Kalita. Also heard Mr. M.K. Chowdhury, learned senior counsel for the respondent number 1, assisted by Mr. Yes, Mr. Chowdhury, assisted by
PP Medi, Mr. PP.
P.B. Medi. Also heard, who's the next? in line. Thank you. No, no, Mr. A.K. Bhuyan. For the respondent number? For BTC.
Milord, kindly take note of one thing, Milord. Why they have not annexed the UGC's affidavit in this appeal? No, no, Milord, this is a serious matter. A writ appeal will be complete only when all the pleadings are submitted. Where is the affidavit of UGC in this appeal? Why it has not been submitted? What I say?
Okay. Respondent number, Mr. Bhuyan?
Yes, all the BTC respondents,
No, no, that is what? Numbers
that is my lord.
2, 3, 4, and 5.
2 to 5.
2 to 5.
Mr. KK Day appears for respondent number 6. Miss Dr. C. Agarwal appears for respondent number 10, bracket UGC. Right. The issue to be decided in this appeal boils down to whether the respondent number 1 has got the eligibility criteria for taking part in the selection process for filling up the post of assistant professor.
Principal, man.
Huh?
Principal.
Where is that? Acha. For post of principal, Goreshwar College. In terms of clause 5 of the advertisement dated
1/1/2023.
1/1/2023, comma, wherein it is stated as follows. Page 54 in blue app. Page 54. Next paragraph. Right. The appellant and the respondent number 1 had taken part in the selection process in terms of the advertisement for filling up the post of principal of Goreshwar College, wherein, wherein the appellant secured
400.58 marks.
400.58 marks, while the respondent number 1 secured
427.4.
427.4. The selection committee recommended the name of the respondent number 1 for appointment to the post of principal, keeping in view the fact that she had secured higher marks than the appellant. However, the state respondents appointed the appellant to the post of principal on the ground that he
is a permanent resident of
the permanent resident
of BTC area.
of BTC area. Next paragraph. The respondent number 1 being aggrieved. Next paragraph. The respondent number 1 being aggrieved by the appointment of the appellant who had secured lesser marks than her, the respondent number 1 filed WPC 3543 of 2023. The appellant in his affidavit in opposition in WPC 3543 of 2023 took the stand that as he was a permanent resident of BTC area, there was no infirmity in the decision of the state respondents in appointing the appellant over the respondent number 1.
The stand was also there that, my lord,
the post of principal.
That stand was also there that the respondent one is not eligible. That stand was taken.
In which case?
Full stop.
It was not taken.
In the affidavit in operation.
No.
Where?
He has read that, my lord.
No, that is
in his writ petition, my lord, he has only stated.
Just a minute, both of you all just a minute. 197. Let me see. Just let me see.
That stand is in my,
Just let me see. That is 197 is your writ petition.
yeah, that is in my repetition, yes.
491. Anyway, how does that matter now? That does not matter. I'm getting confused now. Where am I? As the same was in consonance with the conditions laid down in clause 10 of the advertisement. Next paragraph. The appellant thereafter filed WPC 598 of 2024. Against the respondent number 1, stating that the respondent number 1 did not have the eligibility criteria for participating in the selection process for the post of principal, as the respondent number 1 did not have a minimum of 10 research publications in peer-reviewed or UGC listed journals as required under clause 5 of the advertisement. Next paragraph. The learned single judge thereafter they passed a common judgment and order dated 3/9/2025 disposing of both WPC 598 of 24 along with 3543 of 23 by holding that the issue of preference to be given to a person residing in the BTR area would only come into play when all other things between the two parties were equal. As the respondent number 1 had secured higher marks than the appellant in the selection process, the preference clause could not be applied by the state respondent. With regard to the issue raised by the appellant that the respondent number 1 did not have the eligibility criteria for participating in the selection process, the learned single judge held that the issue raised by the appellant was an afterthought. Next paragraph. The learned single judge thereafter set aside the appointment of the petition, appointment of the appellant, appointment order dated 10/5/2023, appointing the appellant as principal of Goreshwar College and directed the respondents to proceed in accordance with the recommendation of the selection committee by appointing the respondent number 1 to the post of principal. Next paragraph. The appellant's counsel, Mr. M.K. Chowdhury, has at the outset stated that he does not wish to press the present appeal with regard to the issue of clause 10. Regard to clause 10. No, clause 10.
Preference.
Preference.
Preference clause
10.
Oh, sorry.
issue of clause 10 as the decision of the learned single judge appears to be correct. Full stop. However, he submits that the respondent number one is not eligible to participate in the selection process for in terms of clause 5 of the advertisement, inasmuch as the affidavit, no, as much as the annexure 1 colli, no, bracket colli, KCOLL1 colli, of the affidavit in the possession file on behalf of the respondent's number, on behalf of the BTC, on behalf of the response number 2, 3, and 4 by the Director of Education BTC shows that the respondent number 1 shows that the meeting minutes of the committee constituted for re-verification of the research papers published in journals submitted by Dr. Pratibha Patwari, bracket respondent number 1, and Dr. Pramod Medi, bracket appellant, on 4/4/2024 showed that the respondent number 1 did not have the eligibility criteria as required under clause 5 of the advertisement. Next, Mr. K.N. Chaudhary, the learned senior counsel for the respondent number 1, on the other hand, submit that the eligibility criteria of the respondent number 1 was never an issue, even at the time of recommendation made by the selection committee for the post of principal, wherein the vice chancellor of the Bodoland University was present. He submits that the issue of the respondent number 1 not having the eligibility criteria has only now come into the picture with the committee constituted for re-verification subsequent to the issue raised by the appellant, which is suspect. Which is suspect, SUSPECT. Next panel. We have heard the learned counsels for the party. As stated in the foregoing paragraphs, the only issue to be decided is whether the appellant, the respondent number 1, has the eligibility criteria for being considered for participating in the selection process in terms of clause 5 of the advertisement. The selection of the recommendation of the respondent number 1 by the selection committee for appointment to the post of principal implies that the respondent number 1 had the eligibility criteria in terms of clause 5 of the advertisement. However, the subsequent meeting minutes of the committee constituted for re-verification of the research papers submitted by the respondent number 1 and the appellant on 4/4/2024 shows that is to the effect that the respondent number 1 does not have the eligibility criteria. On considering the entire issue at hand, we are of the view that as the constitution of the selection committee who had initially considered the research papers of the parties is different from the committee constituted for re-verification of the research paper on a subsequent date. The BTC authority should produce all the records pertaining to the research papers published in journals and
Along with the application.
published in journals and in peer-reviewed, published in peer-reviewed or UGC listed journals.
Yes.
On the next day. List the matter on
Five.
five. Five says so, okay. Five says. Full stop. It may be stated here that in terms of the affidavit filed by the UGC, where is that a page?
Page 437, my lord. In fact, this honorable court wanted to know both the status of both, not only me. Kindly see page
Yeah, that's
437.
why I
para
asked
eight.
for both.
Yes. So lordship has said respondent number 1.
No, appellant also.
Affidavit is at page 425 and the table with regard.
Yes, that table.
At page 439.
Where it may be submitted here that we have also noticed para 11 and 12, para 11 of the affidavit submitted by the respondent number 10 bracket UGC.
In WPC 598.
In WPC 519 of 2024. Where have you stated with regard to four or five journals of these?
None of the article of the appellant is in care listed journal. Page 439.
Just say that.
That published.
Hmm.
As on that date, there were 5 articles which were in UGC care listed.
You just give me that on the next day.
That will be better.
You give me that, all those in the next day, okay? That's all. Which are? List the matter. Last, what is the list? Which shows the research paper submitted by the parties. List the matter on so and so, on which date the council for the UGC shall specify, shall give a specification as to which of these research papers qualifies.
With regard to peer-reviewed journals, UGC cannot.
Okay.
That will be reviewed.
Qualifies with regard to the
With regard to the UGC care listed.
with regard to the UGC
Care listed.
journal.
Not care listed, care, UGC care listed.
Is it care or peer?
Care. Peer reviewed is separate, and UGC care is separate.
Out here it is. It's out here, it says peer. It does not say care.
Peer reviewed journals is one category which can be taken into consideration.
Care cannot be taken.
And the second which can be taken into consideration, it is called either UGC care listed journals or it is also called UGC listed journals.
Okay. What have I said? Give a clarification. Peer listed,
Not
peer reviewed and UGC care listed journal. You cannot give. Acha, just say UGC care listed journals. She submits that the UGC listed journals includes care listed journal.
UGC care listed and UGC listed journals is one and the
Okay.
same.
He submits that UGC care listed journals includes listed and unlisted journals. No.
UGC
Care listed journals is equivalent to UGC listed journals.
Listed.
Okay, she submits that UGC care listed journals is equivalent to UGC listed journals.
Yes. Deeply.
Your lordship will protect you, well.
Huh?
Next day, your lordship.
They are not, well, I am not going to initiate any content.
That with regard to some actions being taken in the executive council, let it be outcome of the repetitions, my lord, will obey by that. That
So, my lord, my submission is that, my lord, my learned friends already submitted, they have decided to comply with the
Yes,
judgment.
ma'am.
Your lordship is examining the matter, my lord.
Yes, yes. Okay, we've heard. That till a final decision is taken, don't say till the next date. The
Status quo as on-
quo as on date shall be maintained till the next.
Yes.
Nice.
Deeply.
Item 12.
Item 12.
Just one more thing, just one more thing. Hey, just one more thing, just write one more thing. It is also noticed that what is that, 465, or 465, and the signature of the chairman is absent. The signature is not. This one. From AK Buyanas. 12.
This come for consideration for the interim prayer, my lord. Suspension of sentence, man.
Item 12, my lord, as per my instruction, service is complete.
So you can argue.
My lord, but here, my lord, last occasion we took time to file objection, my lord.
You have filed it.
We'll file, my lord.
You have filed it already.
We have not, my lord. As
You have not filed.
we have not, because, my lord, my,
You have not filed.
yes, my lord.
It's a love story, actually, my lord.
Huh?
The girl was having an affair with that boy, my lord.
Next week, any date, my lord, Mrs. B.
Listing of the appeal.
Huh? Huh? It will happen. They say registry to list the appeal after 2 days.
Lordship,
After 2 days.
no, Lordship, on 8th of December, because tomorrow onwards, as I told, I'll be on leave.
Oh, okay, 8th December. So we thought we'll give you this week. You're in a hurry.
Lordship, I don't have an option.
On 8th.
Deeply obliged.
Item 21.
Lordship, in this case, we have taken usual steps, but the dusty service yet to be affected. Let it come after 2 weeks, Lordship, because spread over different reason, Lordship. We have taken the back the petitions, but yet to cause the effective service because spread over different reason, Lordship. 2 weeks time may be granted, Lordship.
To what?
Dusty service, Lordship.
So you have not done dusty till now.
Means that those things has not returned back us, the acknowledgements.
No, but you also allowed to take dusty.
Dusty is, Lordship.
It was allowed. Let dusty notice also.
I have taken back the petition has been taken back from the registry, but we have to got affected the service to the respondents.
Right.
Yeah.
Mr. B. Chakrabarti, counsel for the appellant. Appellants. Praise for how much time?
Lordship, this is writ petitioners. It can come up from the central
For
administrator.
the writ petitioners. Praise for how much time?
2 weeks time, Lordship.
2 weeks time to file, to serve notice upon the respondent through dusty service. This is the matter of 2 weeks.
Deeply obliged.
Item 16 for hearing.
May it please your lordship. Although this matter would have different limbs of argument, I would like to bring it as close as possible to a fewer limbs, my lord. There's a person in the Air Force. He was show caused. He was a habitual offender, my lord. All of drinking and intoxication. I'll be very fair. He was show caused. He submitted the reply. Eventually discharged from service.
This item?
16.
Yeah.
But it's all realms of intoxication. He was show caused. He was a habitual offender. He was show caused. He replied. He was discharged from service. Eventually, the AFT, my lord, so rejected, as against which we have before Armed Force Tribunal. So rejected, against which will be in this honorable court. Now, since there were 4 red mark entries, the learned tribunal proceeded on the premise that 4 is there, disciplinary force, although not so rigid, but we would like to go ahead with the dismissal order. Now, this boils down to the question that what legal grounds do I have apart from factual to address my lord? That's a fact that he's poor and all that. I'll come to that later, but on the facts, my lord has the show cause notice at page 17 for a moment, 17. Yes. Look at yours.
Yes.
17. May I read, my lord? That's 6th of December 18. My lord would kindly note the date. That would have a relevance as I proceed in my argument.
How long will you take?
Not much. It clicks, it clicks. If it clicks, it clicks. One shot. Not much.
Okay.
I just read it out. I can straight away come to the 4th paragraph. It will be relevant. May I read that? And whereas in spite of the said warning, you have again indulged in an act of indiscipline, that is at 11 BRD AF at about 20:30 hours on 19th of August 18. Found lying under influence of liquor near Air Force Dhaba, Ojhar, while on QRT duty, when checked by so-and-so Santosh, shift so-and-so, thereby incurring one more red mark entry in 10th September 18. So this marks the 4th entry, my lord. I'm just being as brief as possible. The earlier one says about 3. The paragraph 3, it starts with, and whereas you have incurred 3 raiding punishment entries. Now this marks the 4th one. So 4th one was 10th September 18. My lord kindly takes care of the date.
Huh? That was on 10 September.
That date would be again relevant. I'm being as precise as possible, my lord. Now, page 18. Penultimate, what do they want? What do they show cause me on? I put that question to myself and the answer is, now therefore, you are to show cause as to why you should not be discharged from service under Rule 15(2)(g)(2) of the Assam Force Rules 1969. I mean, Air Force Rules 1969. If Lordship has the acts, it's...
Yes, provided they have given it to him.
We had given a copy, I believe. This is unsuitable for retention in the Air Force, 15(2)(g). Air Force Act. If you're having the same book, page 61. That's 15(2)(g). Unsuitable for retention in the Air Force. 61. If you're having the same book, 61. Rules. Acts would have the rule. The Act has the rules. Rule 15.
Which rule?
15.
69. Okay, page 59.
It would vary here and there. 15(2)(g). It's here in the chart.
15(2). G.
G.
15(2)(g).
That would be at page 61 if Lordship is there on the top.
Yes.
15(2)(g)(2).
Page 61.
Yes, 15(2)(g)(2).
15(2)(g).
Unsuitable for retention in the Air Force.
Yes.
On that, I was show cause.
Yes.
Now, once I was show caused, I must have replied and replied in detail. That is at page 19
I would not read out the reply. I'll just point it out. Page 19. The Lordship finds page 20.
Yes.
Now page 21.
Yes.
Paragraph 6 onwards, it's a detailed reply. 22. Lordship has it. I'll not even read it, Miller. It's a detailed reply. Now my Lord finds my discharge order at page 33. I'll not even go to the reply. It's a narration of denial. Page 33.
Yes.
That's my discharge order. Would my Lord have page 34, the paragraph 7?
Page 34.
Yes, paragraph 7. In continuation of discharge order. The last paragraph. I said I'll be as fast as possible.
Yes, yes.
Paragraph 7. This last line.
Yes.
And no defense whatsoever has been taken by him for exoneration in his reply to the SCN. Absolutely, that is perverse, my Lord. It was a detailed reply with all defense taken. This discharge order fails here. This is where I was not heard. This is where my stand was not being considered. This is how the entire order falls through, my Lord. I moved on to the Armed Force Tribunal. This one line is the sheet anchor of the case, my Lord. I may read the entire thing. They have not dealt with my reply. Number one, and I'm entitled in law to have my reply heard, considered, and then rejected, of course. Now I move to the Armed Force Tribunal. Once I move to the Armed Force Tribunal, the AFT order, the Armed Force Tribunal order starts at page 57.
So with regard to all these,
My explanation.
no, so these four charges of misconduct.
No, there's only one. Why you should not be heard under 15(2)(g)(2). This is because it's not a court martial. This is on the habitual offenders policy,
So called notice with regard to all the four incidents of getting drunk. Is it?
I'll come to that, Miller.
Or is it only in one?
No,
This
it would deal with all four.
It's for all four. The act
But the
of
fourth
incident.
one triggers it because it's the fourth red mark entry. I become a habitual offender. May I just have it for a moment? This will be the policy holding the field. For the fourth one, it triggers up all. Till 3, it was okay. It's very small in font. I could not have a better one, Milo.
Have it right.
I tried, Milo. Last occasion also. So Milo has it at next page, Milo. Paragraph 5.
Yes.
May I read?
Yes.
Habitual offenders policy. May I read, Milo? Criteria. Airmen or NCE who meets with any one of the following individual criteria is to be treated as habitual offender and his case is to be considered for discharge after issuing a show cause notice. May I pause and read 3-4 words again? And his case is to be considered for discharge after issuing show cause notice. So therefore, there is no consideration for discharge until and unless a show cause notice is issued. And B, 4 red mark entries, I squarely fall into that, my Lord.
Yes.
So, due to on 10th September 2018, I hit the 4th red mark entry, and therefore, in terms of the policy, I become a habitual offender, rightly, wrongly.
Correct.
But until they have issued a show cause notice, they have not considered me for discharge. And that consideration of discharge came on 6th of December 2018.
Correct.
Now, my Lord, on 22nd of November 2018, in the gap, 10 September to 22nd November, my fourth red mark to being a habitual offender until the show cause notice was issued 6th of December,
Your fourth reading came on
10 September,
Huh?
10 September. So the policy is invoked. But until a show cause notice is issued, I am not considered for discharge.
Correct.
This came on 6th of December.
Your show cause.
Absolutely. So the clause 5 would be invoked. 5B comes in on 10 September, but 5 comes in on 6th of December. Could I make it, Milord?
What 5 are you talking about?
5 is, and his case is to be considered for discharge after issuing a show cause notice. So regardless of the fact that, this policy, Milord, clause 5.
Yes.
And his case is to be considered for discharge after issuing a show cause notice.
Correct.
Therefore, 5B is triggered on 10th of September 2018, while 5 simpliciter is 6th of December 2018, when they issued the show cause notice. I'm on that. In the interregnum period, in the intervening period, page 55, 22nd November 2018.
Page 55.
22nd November 2018, affidavit. Page 55. May I read, Milord? 22nd November 2018.
28 November.
28th November 2018.
Yeah.
That rate is relevant because it's in between the gaps.
Yeah.
I, at number 2, LAC, leading aircraftsman Deepjyoti Talukdar, Milord.
Yeah.
Deepjyoti Talukdar, Milord.
So what does it say? Struck.
Promotion.
Huh?
I was promoted, Milord. These are promotion orders.
So you're promoted.
I was promoted to the rank of a corporal.
November.
28th November 18 with effect from 1st of July 2018.
Yes.
What I mean to say is that, with all humility, after 10th of September 2018, my case was processed at all angles in the official, and they took a call to promote me with effect from July, and they did not take a call to discharge me. The call to discharge me came on 6th of December after the promotion was given. These are two limbs of thinking. They are thinking at the same time. Now, how it affects me?
You're promoted to what?
Corporal.
Huh?
Corporal.
Corporal.
Corporal. Now, if my lord has the act. No, not act.
Your discharge order dated?
Discharge order is dated, my lord, 26/8/19 in the next year.
In the next year.
In the next year, that's perfect. No difficulty on that score. Now, how? So what I'm trying to submit, my lord, 10th of September, I became a habitual offender. I put the question to myself, on what way do they proceed? Do they proceed to discharge me under 15(2)G2, or they want to promote me? The answer is they promote me on 22nd November 2018. They do not proceed to discharge me. They proceed to discharge me on 6th of December. In terms of the habitual offenders policy, until the show cause notice is issued, they have not considered for discharge. So therefore, 6th of December, they proceed to discharge me, although I was promoted earlier. Now, the legal question would be, what is the effect of the promotion? Or whether the promotion can be given effect to simpliciter by the order, or there has to be a physical effect of promotion, which they are taking. So the Act, Section 82. At page 28, my lord would have Section 82. This is on the legal side I'm arguing, my lord, but the first part that I was not even heard, my reply was not even considered, is enough for a reconsideration. They didn't even go to that. What is the legal lens I'm arguing? If my lord may permit me to. Section 82 at page 28. We're having the same book, my lord.
Yeah.
So these are the punishments, my lord, A, B, C to J, which can be given without a court martial. Some require sanction of the court martial, some do not require sanction. That's perfect. But these are the punishments can be given. Mine was detention up to 28 days. That's A, 82A. Would my lords kindly come to section 84. Limit of punishments under section 82. My lord has that?
Yes.
And I invite my lord's attention to 82 subclause 4, subsection 4.
84.
84 subsection 4. May I read, my lord?
Yes.
The punishments specified in clauses A, B, C, E, G, and J of section 82 shall not be awarded to any person who is of the rank of non-commissioned officer or was at the time of committing the offense for which he is punished of such rank. Meaning thereby, if I become a non-commissioned officer by virtue of the 28th November order with effect from 1st July, then you could not have given 82A detention up to 28 days. You could not have detained me. Therefore, I would not have incurred the 4th red mark entry also. Because you show caused me in December. You did not proceed to discharge me on lines of discharge to show cause. They did not do so. They proceeded to promote me. They have an answer to that. I'll even address that part also. After they did not decide to discharge me, my lord, after 10th of September, they decided to promote me. And so they did on 28th of November with effect from 1st of July. If that be so, I become a non-commissioned officer from 1st of July. Then 10th of September, the 4th red mark entry they cannot have been given because 82A detention is not permissible by view of 84(4). That's broadly the second line, which I'm trying to submit. Now, they have a legal answer to that. It goes against me, but I must open up. It says, no, you require a physical confirmation. And those cases where these things are pending are kept on hold. And they relate. If Lordship has the affidavit filed by the respondents, I'll straight away take you that. It goes against me, but I'll read that. The affidavit filed by them in opposition at page 80. Their answer to my contention. That's all. My ladyship has it. Page 80 of the affidavit. 80. May I read that part? Paragraph G. May I read?
Yes, yes.
Whereas para 37 of AIR HQ/C 40651/PA CPC dated 14/1/15 promotion policy airman states promotion to habitual offender whose case has been referred to air headquarters for discharge under habitual offender category is not to be granted by the unit. Such case are to be referred to AOC AFRO by signal accordingly. This is important. The same was intimated to AFRO by signal number so and so 3/12/18, meaning thereby, my lord, on 3/12/18, a decision was taken to discharge me. 6/12, the notice was issued. Cannot keep my promotion on hold. First you promote me, then you take care of this 3/12 and 6/12. If the promotion succeeds, why not?
Well, the promotion process might have started a long time back.
No, I'm not on that. It was effected on 22nd November by 4th red mark entries 10th of September.
Huh?
My 4th red mark entries 10th of September.
Yes.
They decide to discharge me on 3rd of December. And they issued a show cause notice on 6th of December.
They decide to discharge you on 6th of December.
6th of December. I even take that to 3rd of December when the signal was sent. Let me take it earlier, but by virtue of the policy, it comes into effect on 6th of December. So, once you have promoted a man and he gets a benefit, can you later on say that no, prior to promotion, there was a 4th trademark entry? We'll invoke that now after the promotion. Perhaps this is not permissible in law. They could have done so prior. Certainly, they could have done so. On 10th of September, they could have said, No promotion, nothing. We'll proceed 15(2)(g). On law. But first and foremost, Miller, once I was not heard at all.
You mean 5(2)(g).
15(2)(g), 2. 15(2)(g)(2). That's the rule. Oh, 5 of the habitual offenders policy. Yes, 5. Simpliciter 5.
Which one are you going? Where is this 15(2) you're talking about?
15(2) is of the rules. 15(2)(g) is of the rules. As page 61. My was show cause under 15(2)(g)(2). Page 61, Milo.
So your basic case is that you cannot be discharged after your promotion.
But prior to that, you cannot discharge me without hearing me. They have not heard me. Although it's an eyewash that they've heard me.
Where is the discharge order?
Discharge order at page 33, Milo. Where I'm hitting is 34. I'm bound to an audience. 33, Milo. Paragraph 7 and 34. The last line. There's another one error which I've kept in, Milo. They say 5. I'm only on I'm not being heard, Miller. Rest we can argue it out if I'm given a chance to contest me before the authorities. I was not heard. I'll take all the pleas if required, Miller. I'm only in.
Let us see your reply. What did you say?
Yes. My reply starts at page 19. From 21 onwards, it's detailed, offense-wise. It's a long one, Miller. Lordship has the point-wise replies of every offense and a detailed, elaborate replies.
This first case of 4th November,
Man.
this you have denied, is it?
Yes.
This
I have also narrated the explanation.
But second case, this you have not denied.
No, we have. No, it's not on the denial part, Miller. It's on the red mark entry already comes in
Correct.
It comes in regardless of whatever I say. What I am submitting is that this show cause reply had its total narration. Kindly don't take any action against me. That's the sum and substance of the show cause reply. The authority proceeds on the premise, he takes only first 2 pages. The authority, if Lordship has the order at page 33, what does the authority do? What he does is that he takes the first 2 pages, does not even flip over to the rest of the pages, and he says there's no rest stand taken.
There is no?
He says at page 34, no defense whatsoever has been taken by him for exoneration. The entire thing is a defense, in seriatim. All these pages, not even looked. He only takes care of the first 2 pages. He's a poor man, hails from Assam. That cannot be the way you look at people from Assam. You have to take a concrete view of what I've stated. I'm only on this part, my lord, for the present. The legal limb part will come later.
Look, the first
My lord,
3 incidents,
my lordships.
you have been punished.
Even the 4th one,
Yes, sir. So this, and you have not put a challenge to this anytime.
no.
Now, with regard to the 4th one, you have said that I went to Airman Bar and took only 2 peg of rum. As authorized.
Well, I should not be saying that, but
You have said here, you have to take 2
Correct.
pegs of rum.
correct.
However, maybe due to empty stomach for full day, the 2 peg of rum made me serious. And meanwhile, while coming to correct it, I had fallen down on the road
My
in
lord,
front of Air Force Daba.
my lordship.
So you were drunk.
I come to this point. May I read that and then reply to whatever queries put me on? May I read that at page 22?
Yeah.
Drinking is not an offense. Getting intoxicated is also not an offense. Permissible drinking and permissible intoxication is even permissible for everyone in this room, Miller. The point is, in the defense services, they take intoxication under section 48 for court-martial. Only in view of section 82, it comes under lenient punishment. But the red mark entries come in, Miller. D. I was detailed at QRT for duties for 1 month. From 1st August 18 to 31st August 18. On 19th August 18, I was detailed for morning shift from 7 hours to 13:30 hours. Along with night shift from 19:30 hours to 7 hours. Kindly consider the way he's working with it. On next day, and accordingly.
You're not the only one in the army.
No, I'm not on that. I'm not on that. May I read it, Miller? And on next day, and accordingly at 19:30 hours, I had drawn the rifle and had kept under a specified safe custody with lock and key on that day. After my morning duties, I was feeling weakness, and in the afternoon even, I could not take lunch, and without dinner, again came in the evening for night shift QRT duty. Further, when I felt hungry, I placed order for packed food dinner from Air Force Daba, and accordingly at about 20 hours, at 8 in the evening, I went for collection of ordered food where Dhaba person said that for packaging dinner, he would take some time. Then I went to Airman Bar. This is where I say permissible drinking, Vinod. I went to Airman Bar. I did not go to a Teka. There's a huge difference in me. And took only 2 pegs of rum as authorized. It's a bad day, Vinod. I would like not to say it that way. Someone who does not have
You
proper...
fell on the road because
Absolutely. Anyone would fall from Vinod. This is... Had it been considered by the authorities, when I took authorized drinks, Vinod,
No, you that is only what you said you have taken.
Correct. It's recorded.
You see, whatever you have said is not the gospel truth. For the simple reason that if you have been taking 2 pegs of rum throughout your life, I don't think you'll fall down on
Well, some bad day, many people would topple down. But regardless of what I say, this is not the allegation or the statement he went in outside. He had the quota drinks, in the Army, Navy, Air Force, they have the quota drinks. He had 2 pegs and suddenly on a bad day he went out. But this was not even considered, One poor man loses his job with no one listening to what he's saying, Let the authority at least consider it, because it's a red mark entry, It's not mutiny, it's not desertion, it's not theft, it's not local something. At least they consider. They have not even considered it. No one considered my story.
You are the custodian of a weapon.
No, placing safe weapon.
Responsibility is far higher
Absolutely, my lord.
than normal.
Kindly see, my lord. We have read it. I have just read it, my lord. I had drawn my rifle and kept under specified safeguarded with lock and key. I have done my part and my authorized drinks I had taken. Sometimes it goes wrong. But had the authorities at least considered what I was trying to say? They did not consider me, Lord. I would pray for a remand to consider this point and no more. Four red mark entries is not that which would invariably and inevitably lead to a dismissal from service.
Four entry mark, 4 red mark entry.
Is only for
This is
defense.
the only time you were caught. There must have been
My lord,
numerous.
that would be that would be the speculations. I have not read the earlier. What I am submitting, my lord, at least the authorities will consider my case, read my statements, and then they had the opportunity whether I actually had it in the airmen, what I did, what I did not do. I had not done anything wrong, my lord. Only I toppled down. Yes. In a game of 2 pegs, my lord, I toppled down. It happens. It happens. In all fairness, it happens, my lord.
I doubt you had 2 pegs. Probably you had maybe.
Probably I could not have, my lord. Under that, I cannot sneak in. I cannot smuggle in the bottle, my lord. I cannot.
You see, you have got. You see the army people.
My lord.
They are friends. The wet canteen person might be your friend.
No, no.
Club
These speculations, in the realm of speculations, I pray, my lord, I get the benefit of doubt.
At the end of the day, you fell.
My lordship would kindly consider, I fell, and that does not tantamount to losing my job, my lord, when everything else was in order.
And this is not the first time that
My lordship kindly considers they did not even look into my reply. They did not even look into my reply. I do not go to the legal stand of the law that of the corporal, non-corporal 82, 84-4. Only on that, my lord. Let them take a call. He will not object to that, my lord. Let them have a say.
Yeah, Mr. Mehdi.
Whatever it was on duty. Whatever liquor was taken, it is on duty. It is not.
He drank while he was on duty.
With arms, madam.
Without.
And it is fourth ink, madam.
Huh?
Fourth. And thereafter, madam, initially, before that.
No. After I put it on record. After I completed my duty hours, I kept my locks and then after I have it gone. That is not coming in the order of discharge also. They say there is no defense. I put in my defense on record.
Initially, in the training time, it was there, my lord. It was not counted, my lord. And thereafter, my lord, he was repeatedly warned, my lord. His counsel, my lord. Counseling was given, my lord. On last, my lord, is on the duty, my lord, with arms, my lord. And interestingly, you have already read this his statement. I was feeling weakness afternoon, even I could not take lunch. But lunch was not taken. But he took.
And also without dinner.
Without dinner also not taken. He took.
He could not take food. He could take.
Yes, my lord. He is the such type of gender.
If he has completed, my lord, the order of discharge.
Let him give him a chance to say.
Again, coming in the evening subsequent quarter duty. Further, I feel hungry. In place of the order for paid dinner from so and so dhaba, accordingly, I went for collection of order of food where dhaba person said that for packing of dinner it take time. Then taking time, he again drank.
Well,
I went to the Yeoman bar and took only 2 peg of rum and as authorized so and so and returned back dhaba immediately. However, maybe due to empty stomach, maybe and full day, that 2 peg rum made me serious. And meanwhile, while coming to collect the peg, I fallen down. Wrote so and so. So he knows that maybe but even the empty stomach whole day he was no food in the stomach. He took drink. This is habitual. My lord, he was several times in my affidavit. I've stated several times, my lord, in from the training period. My lord, we question, my lord, he's warned, my lord, because of his health, my lord, his fatty liver also there. Everything was given. This discipline organization, my lord.
And the dhaba is outside the camp or inside the camp?
My lord, outside. It is outside. And my lord, and so far the promotion is concerned, it was my lord, Udell, my lord, and he was in super in discipline organization army on this defense, my lord. When physically it was given, my lord, then only this
promotion is effect is from from that, my lord. When physically it was, my lord, suppose bears and everything was given from that, it was counted, it is counting. Not my lord, and so far once my friend already read, my lord, the page 80 of my affidavit, that meantime the applicant passed test of skill TOS in third and last attempt. Not the last attempt he passed in January 2018. Result of same was declared in June 2018 due to delay passing CPE and towards promulgation. So corporal substitution promotion was delayed.
Where are you reading?
Page 80, my friend already did it.
Sarah? G.
F. Due to delay in passing CPE TOS promulgation, PRO for corporal substitution promotion was delayed by adhering to the administrative procedure. That is audit so-and-so. However, CPL promotion was given with respective effect so-and-so, dated 28/11/2018. So, my lord, there is, my lord, he was, the promotion was, my lord, given, but the effect was not given, my lord. This the only, my lord, this one physical, my lord, this, then only it is counted, my lord, effect, my lord. So, so far that part, my lord, this, and that part, my lord, did, so, he was not the non-commissioned officer, my lord, non-commissioned.
Huh?
No,
question.
No, non-commissioned officer. He is not gonna, he is not a non-commissioned officer, my lord. So whatever this section 82 and 84 is my read, my lord, not attract his case, my lord. And completely, my lord, is the discipline organization, a man, my lord, is from the date of so for my epidemic, everything explained, my lord. In various time, it was on, my lord. So this is the way, my lord, is only this, and your lordship may read his reply, my lord, this paragraph, my lord, the how the man of a discipline organization, his reply, my lord, paragraph 4, page 19, page 19 of the writ petition. In fact, as a defense personnel with a view of boss is always right.
Huh?
Boss is always right. His reply, my lord, paragraph 4.
So can you read?
19, my lord. Initially, without
Page?
page 819.
19.
Yes, my lord. Paragraph 4.
Read the entire paragraph.
Without, in fact, as a defense personnel with a view of boss is always right, initially without any arguing and pleading. In good faith, I innocently accepted whatever the right or wrong has had been done to me. Even by seeing the continuous illegal instance happened with me, I had lost the faith on our system. But now, after receiving the so-called notice, considering reasonable chance given by the esteemed organization to prove my innocence and to say something in my defense, I am very happy and again assume that a full faith in our system that the principle of national justice, especially the ODL program or legal axiom, is still alive in our system. Esteemed organization is now, and now I full faith the appropriate competent higher authority would definitely so and so so and so. So my
Study my defense.
his conception is the boss is always
No, it's a
so that way he gave the reply started my lord.
how can they express it that way?
So and
Such a beautiful paragraph.
so all this thing, my lord, this if such type of man is allowed, my lord, and the representative is again, my lord, is allowed to reconsider, my lord. That is, my lord.
Recently, I got these two communications paper. I mean, pointed out. I will just hand over.
And so there is no wrong in.
I pray only they consider me once, my lord. Such a poor man, such honesty he has. 2 pegs of ram from authorized. Suddenly topples down. This is what I get, my lord, recently.
You see, a lot of people drink, especially in the Northeast. I've had many drivers, private and non-private. We see a lot of things in real life.
So now what?
It's not what you say.
Yes, ma'am. Only
No, what
why
is-
he is, ma'am.
I've had,
No, 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 no.
I've had so many
I'm not on the wrong side of it.
cards also. And so many people.
I understand, but
It doesn't happen with two.
Madam, I only pray that they would have considered my reply and they would have said that thing in my discharge order. They did not. They say I have not taken any stand. At least read what I have said. I have run so many, and that paragraph he's reading, it goes against them. I'm so honest. I say now my faith is reposed. Kindly see this letter which I've got now, from the authorities. This 27th of August 25 now. With reference is made to this is belated release medical board. Now they want me to appear for release medical board now.
it is system, ma'am.
I don't know how they are doing it things.
Why don't you go first?
No, I'm not the job. They want to complete the form. But I only pray. Lordship, I'm not getting my service back. I'm only getting a chance to be heard again. That's all I pray, my Lord. And they cannot be shying away to that extent, my Lord. Once given a chance to be heard, I'll place my case again, on the same documents. I would not add a word to it, my Lord. I would not add a word to it. Only my matter be considered. That much. Nothing more. I don't get my job back. Only that much that they consider and pass an order afresh. We'll contest again, my Lord. We'll again go to the AFT if need be. We'll again come back to your court. But let them at least have a take it call. This much, my Lord.
I think we'll adjourn the matter for the time. We'll let us take.
Arrest my case, my Lord.
We'll list it again. You don't want to.
Except first, third, and fourth.
Huh?
Except first, third, and fourth.
Eight?
Fair enough.
This is the matter.
No, right, Lordship.
No, madam. Fifth, madam.
We have already fixed too many.
Heard in part?
No.
11.
15.
11.
No, 15, madam.
Right, Lord.
No, 17, madam. 17.
Okay, 17.
You see, I'm out of session, madam.
Okay, 7.
Right for me.
Yes, what is this case?
This is a writ appeal filed by the state, the against the judgment dated 8/5/2024. Lordship will find the judgment. It is available at page number 92, Malad.
Page?
Page 92, Annex 3.
Yeah.
Basically, Malad, by this order, the learned single judge has directed reinstatement of the petitioner. The writ petitioner respondent herein. Lordship 92, Lordship, page number 92. Lordship may kindly come to para 15, page 96. The learned court has said, Malad, be that as it may, in view of the aforesaid discussions, the order of suspension of the petitioner dated 25/10/2023 is held to be spent in force on expiry of 3 months, as no order of review extension was passed prior to that. The subsequent order of extension would not cure the defect which has already been done. And accordingly, the order of suspension is accordingly held to have spent its force, and accordingly direction is issued to reinstate the petitioner in service. However, taking into account the serious nature of the charges and also the involvement of the and arrest of the petitioner in police case, the respondent authorities are at liberty to post the petitioner in any non-sensitive post. But before I take your lordship to the grounds of the petition, my humble submission is already the departmental inquiry is at the last stage. Inquiry report has been submitted, and it is with the authority. The final outcome is just if lordship grants us 3 weeks time, then ultimately it will be over. The departmental proceeding is over.
You don't need to grant you any time. You complete that. How does it matter?
The matter is otherwise for reinstatement. This is against the order of reinstatement. So my submission is
Why that that order, you dispose of your disciplinary proceeding. Where we don't need to give you any direction. So
But-
what is wrong with this order?
Well, in fact, my lord, what we have said, my lord, Lordship may kindly come to the grounds taken, my lord, in the appeal. Well, the conclusion,
No, basically the issue is if the extension
Lord.
is given after the 3-year period, a
3
3 months
months
period is
period.
over, then that extension period has got no effect.
that is what the Honorable Court has said.
So
And
what
my
is
lord,
wrong?
while passing the order, my lord, the decision of the Honorable Apex Court of Ajay Kumar Chaudhary, that has been followed.
Correct.
Para 22.
Correct.
But my humble submission before the Lordship is, in Ajay Chaudhary's case, my lord, it was a long pending case, no DP was conducted, charge sheet was not issued. But in this case, well, in fact, in our affidavit, we have said that this charge sheet could not be initially within 3 months, charge sheet could not be well, served to the petitioner because well, the particular records were not received from the authorities because he was involved in a criminal case. And the documents were sought for and those were awaited. That is why my lord, there is some delay in issuing the charge sheet. Subsequently, when the charge sheet was issued and the departmental proceeding is drawn and it is at the verge of the completion and the inquiry report is already there. Well, it is submitted. It is under the consideration of the authority. So in this case, my lord, that is why my respectful submission is, my lord, already the departmental proceeding has been my lord, done. Charge sheet has been submitted. He participated. My lord, the inquiry is at the verge of completion. So reinstatement, my lord, may not be considered in this case. That is what, my lord, we have said. The Ajay Chaudhary's case, my lord, the law which law court has, my lord, considered that it was a long pending case, my lord, because of.
But that is what the Ajay Chaudhary case says, that once the suspension order goes, then what remains? You have got to take him. It's a case of what? Misappropriation.
My lord, the demand of bribe, my lord.
Demand for bribe. You put him to any post, how does it? He cannot do anything.
Well, that is why, my lord, I have submitted that 3 weeks period is required to complete the entire thing. The entire process will be over by 3 months, 3 weeks, my lord.
Yes.
My lord, what will happen if the lordship directs the departmental proceeding to be completed within a period? It will render the appeal infructuous. Now, what has happened, my lord, that the order of the learned single judge was passed in the month of April. May. There was a contempt which we filed, which is still pending, which was filed in the month of August. This appeal came to be filed after the limitation period, my lord, in the month of November. But that is on the conduct of the government. The submission, my lord, on the merit of the case is that there was a suspension period, my lord, with its survival period of 3 months, 25/10/2023 onwards for 3 months. The extension was done in the month of February. And it is the very admission of the government in the appeal, my lord, that the review meeting which was undertaken for extension of the suspension was also after 3 months. So now the mandate, my lord, the judicial mandate is that he does not need to have documents.
Judicial mandate of the Guwahati High Court.
No, the Supreme Court, my lord, Deepak Mali. Deepak Mali. In fact, my lord will kindly come to page 61 of the appeal, my lord, 61. It is a document of the government itself, my lord. Page 61. Annexure K in the writ petition.
Yes.
This is an OM, my lord, dated 4th of February 2020.
Yes.
My lord, the second paragraph.
Yes.
It is therefore directed that all the senior most secretaries of all the departments shall ensure that the memorandum of charges, charge sheet, is served on delinquent officer/employee before the expiry of 3 months of period from the date of issuance of order of suspension. They shall also ensure that the currency of the suspension order should not extend beyond 3 months. If within this period the memorandum of charges/charge sheet is not served on delinquent officer/employee, if the memorandum of charges charge sheet is served within 3 months of suspension, a reasoned order must be passed for the extension of the suspension, my lord. It is the document of the government itself, and basing on this document, my lord, I have taken 3 judgments, my lord.
Two judgments, my lord. Deepak Mali. Deepak Mali's case was based on the CCS rules, where there was
FR10.
FR10, my lord. FR10, in fact, it is at page paragraph 2, my lord. Under Rule 10 of the Civil Services Rules 1965, as amended by the notification dated so and so.
Anyway, this is a covered matter by.
My lord,
This is a settled matter in this High Court. You know it very well, Mr. Nand.
Well,
What is wrong with this order? There's nothing wrong.
well, para 11, the second paragraph of page has been referred, but we have replied to that. But the problem here in Malad is kindly, if Lordship kindly comes to
Look, you
page 68.
within 3 weeks you pass the order. It's the end of the matter. That's all. But then we have got to uphold the judgment.
My lord, otherwise this will infatuate.
There's nothing. Mr. Tina, then senior government.
Reinstating the petition at this stage,
You see,
ultimately,
the thing is, I understand your anxiety, but the problem is the law is the law. It is not we who have made the law. It has been done by the highest court in the land, and we have got to follow it.
but the fact and situation in that case is different. That is one I am.
Maybe, but then the ratio that applies to all cases now.
In that case, kindly consider, in that case, charge sheet was not even served on the petitioner for years now. In this case,
Maybe.
everything is.
But where
complete.
do we draw the line? Where do we draw the line?
I leave it.
Now, will it be 4 months, 5 months, 10 years? Where do we draw the line?
The charge sheet was immediately on receipt of para 11, page 68. We have said
Maybe,
that
but then
that after receipt of the.
It says within 3 months. It does not say within. You see, there is no issue of rounding off or giving a period beyond 3 months. Very clear. And look at your own document at page 61, which is mentioned.
Yes.
Office memorandum.
Lordship.
And this was pursuant to an order of this honorable court, my lord, which is at page 58.
No, this is it's pursuant to Ajay Kumar Chaudhary, page 61.
Yes, please. But here, the charges were to be definitely within 90 days period has been given, that within that period charges to be submit.
And another thing, they shall ensure that the currency of the suspension should not extend beyond 3 months. If within this period memorandum of charge is not submitted, is not served on the delinquent. If the memorandum is served within 3 months, within 3 months of suspension, a reasoned order must be passed for an extension of the suspension whenever necessary. So even if charge sheet is filed within 3 months, you still have to give a reasoned order for suspension, for continuing with the suspension.
That charge we could not hand over to him. We have explained in para 11 of our affidavit. Basically,
Even if you had submitted the thing or not submitted, you should have taken a decision to extend the suspension period. You did not do that.
it was done, my lord, but giving effect from the month of January.
The review was also done after 3 months.
Yeah, right. Hers is the green Atlanta in the government authority for the appellate stage. Also heard
M. Sharma, my lord.
Mr. N. Sharma for the
sole respondent.
For the sole respondent. The appellant has put to challenge the ensuing judgment and order dated 8/5/2025 passed by the learned WPC 1467/2024. Wherein the suspension of the petition had been set aside on the ground that no review, no order or review / extension had been passed by the state appellant prior to the expiry of 3 months after the suspension order had been issued. The learned single judge just held that the order of extension of the suspension subsequent to the expiry of 3 months. 3 months from the date of issue, from the date of taking effect of the suspension order.
My lord.
Would not cure the defect of not having undertaken a review for continuing with the suspension order. In terms of the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India and another, reported in 2015, 7 SCC 292. And the decision of the division bench of this court in Rakib Uddin Ahmed
My lord.
versus State of Assam, reported in 2019, 5 GLP 600, which was in relation to a case of deemed suspension.
My lord.
Under Rule 6 bracket 2 of the Assam bracket discipline and appeal bracket rules 96. Next part. The learned counsel for the appellate submits that the departmental proceeding is going to be concluded within 3 weeks. And if the impugned judgment and order is to be implemented, the same would cause what?
No, it will just create an
The same would cause
Problem.
would cause a great problem to the appellant as the appellant has been charged with misappropriation of money. Here, the learned counsel for the appellant that submits that the direction to the appellants to reinstate the respondent should be set aside. Is it? That's all.
No, no.
What about the law?
But the allegation is of accepting bribe, and as regard law,
Okay, not misappropriation for accepting bribe.
as regard the law, my humble submission is ground number 3 and 4 I have taken, page number 12 and 13. My humble submission is in the Ajay Chaudhary's case, the charge sheet was not given, and for a particular long period, around 9 years, the person was under suspension. In that circumstances, it was held by the honorable court. But in this case, there is a difference. The fact situation is different, and that is why my humble submission is that
Okay, next.
The-
Para. The learned counsel
charge sheet
for
was
the
already
appellant
given.
further submit that the fact situation in Ajay Kumar Chaudhary Supra is different. In view of the fact that in Ajay Kumar Chaudhary Supra, charge sheet had not been submitted for a number of years. However, in the present case, charge sheet had been submitted. Charge sheet / memorandum of charge had been submitted a few days after the expiry of the 90 days period. 90 days validity period of the suspension order. That's all.
Not.
That's all. Mr. M. Sharma, the head counsel for the respondent on the other hand submit that para 22 of the decision of the Supreme Court in Ajay Kumar Chaudhary makes it amply clear that memorandum of charge, that charge sheet would have to be filed within 3 months from the date of issuance of a suspension order, or else the suspension order loses its force. However, if a review is undertaken prior to the expiry of the 3 months period and an order for extension of the suspension order is issued, the suspension period can be extended. But he also submits that in a case where a department, a memorandum of charge, that charge sheet is submitted within 3 months, then also a decision has to be taken by the respondent for extension of the suspension period. A reasoned decision has to be taken by the respondent for suspension of the suspension period. We have heard the process of the party. Para 22 of the decision of the judgment of the Supreme Court in H.J. Kumar Chaudhary Supra states as follows. A bare perusal of the above clearly shows that statute has to be filed within 3 months. If within the 3 months statute is filed, but then a reasoned order has to be given for continuance of the suspension order. If a charge sheet is not filed within 3 months, the respondents would have to undertake a review for continuance of the suspension order before the expiry of the suspension period. Before 90 days from the date of,
Yes, madam.
from the date of coming into force of the suspension. And considering the above and the decision of this court in Rakil Uddin Ahmed, we do not find any ground to take a different view than the view taken by the learned signature. According that it appears can be.
My lord, if your lordship's order can trace back the order of the learned single judge from date of its issuance, my lord, on 8/5, then it will be beneficial for the respondent here, my lord.
Right.
The effect of the order, my lord, the fact that your lordship had dismissed the appeal, the dismissal should take effect from the date of issuance of the learned judge, single judge's order, my lord, because what has happened, my lord, in the ensuing 17 months, my lord, I have been deprived of that benefit of having reached.
Judgments are always retrospective in nature.
My lord, no, I'm grateful, my lord. I'm grateful.
Oh, finish. Oh, we finish. The list. Oh, this is.
I'm sorry, my lord. By this review application, my lord, I'm troubling your lordship with regard to an order that's been passed on 10/4/2023. This is with regard to non-payment of admitted amounts, my lord. Now we have filed in after 2.5 years, my lord. Only prayer with regard to this is Tamsher Ali, my lord. In the meantime, 5 lakhs was paid, my lord, and as per court's order 14/11/2025, my lord, this with regard to deposit 10 lakhs in the registry, my lord. The principal secretary with regard to BTC, he's like the chief, my lord, officer in a state, my lord. He had joined in very recently, my lord, and all the files has gone into and it is in his table, my lord. Within this week, this will be released, my lord. 10 lakh would be deposited, my lord. That I am on, my lord. And his serial number is, my lord has made a query with regard to this because they followed Tamsher Ali. That is his serial number 115 in the.
What about what is the serial number that has been given?
115, my lord.
No, that is all right. You have given money till which serial number?
That instruction I don't have, because various departments are there, my lord.
That is one. You see, there's the problem is the issue is not of him having a serial number. The issue is when he'll be paid.
Yes, my lord.
We can have an idea because
they have
if he's 115,
my lord,
we have only given till number 2 or 3, then no point.
There is, my lord, the list is the used list, my lord.
Maybe.
And so they have decided with regard to paying 10%. So, my lord, 10% is already been released with regard to this. My lord, way back, my lord. And So far that is concerned, my lord. There are other persons also, and BTC, my lord, doesn't have the finance, my lord. That portfolio doesn't have. That is only with regard to the budget, we, my lord, raise it. The state government pays it, my lord. So we are in the receiving end.
Basically, there is no ground for review.
Absolutely, my lord. I agree. Do agree, my lord. It's
So
a mercy petition, my
We
lord.
are only thinking, the only thing is that you deposit an amount, we'll see, we'll issue notice and then we'll decide.
Yes, my lord, we will, my lord. Just 1 week time may be given, my lord. We'll deposit, my lord. It is under active consideration. Today also morning, I have talked to the officers concerned, my lord. This, my lord, because of the principal secretary got changed, my lord. And all files, all litigations, lot of, my lord, anarchy has been there. He's been trying to, my lord, organize everything as per that, my lord. Kindly accommodate for today, my lord.
Why haven't you given a copy of this review petition to the other side?
Other side, because notice has not been issued, man.
On the prayer of Mr. A.K. Bhuyan shall obtain instructions as to the serial number of the contractor to whom payment has been completed by the BTC. He also submits that 10 lakh should be deposited by this week. Leaves the matter on Friday.
On Friday. Deeply obliged. Deeply obliged.
But I don't, even with that money, just write one more thing. No, let them say.